I call this meeting to order. So welcome to meeting number 110 of the House of Commons Standing Committee on Public Safety and National Security. Pursuant to the order of reference referred to the committee on Wednesday, May 29th, 2024, and the motion adopted by the committee on Monday, May 27th, 2024, the committee resumes its study of Bill C-70, an act respecting countering foreign interference. Before we begin, I would like to ask all members and other in-person participants to consult the cards on the table for guidelines to prevent audio feedback incidents. Please take note of the following preventative measures in place to protect the health and safety of all participants, including the interpreters. Only use a black approved earpiece. The former gray earpieces must no longer be used. Keep your earpiece away from all microphones at all times. When you're not using your earpiece, place it face down on the sticker placed on the table for this purpose. And thank you for your consideration. Today's meeting is taking place in a hybrid format. I would like to make a few comments for the benefits of members and witnesses. Please wait until I recognize you by name before speaking. A reminder that all comments should be addressed through the chair. And specific comments on Bill C-70. As indicated in the memo that was sent out on May 31, I would like to remind members that amendments to Bill C-70 must be submitted to the clerk of the committee by 4 p.m. Eastern Standard Time, Friday, June 7th, 2024. It is important for members to note that, pursuant to the order adopted by the House on May 30th, the 4 p.m. deadline to submit amendments is firm. This means that any amendments submitted to the clerk after the deadline and any amendments moved from the floor during the clause-by-clause consideration of the bill will not be considered by the committee. I would now like to welcome our witnesses for the first panel today. Welcome, gentlemen. And now we have Mr. Charles Burton, Senior Fellow, Synopsis. We have Mr. Michael Kempa, Associate Professor, Criminology, University of Ottawa. Thank you, gentlemen, for joining us today. I will now invite Mr. Burton to make an opening statement of up to 5 minutes.
Chair, my area of expertise is Chinese domestic politics and foreign policy. I was educated in China, and I've worked in the CSE, in the Canadian Diplomatic Service, and as a diplomat, and as an academic. I've published several articles and reports on Chinese influence operations in Canada. I'll focus my remarks on Part 4 of Bill C-70, the Foreign Influence Transparency and Accountability Act part, because that impinges on the activities of agents of the Chinese Ministry of State Security, targeting politicians, civil servants, and others involved with shaping Canada's relations with the People's Republic of China regime. Now, Justice Ogg's report earlier this month noted that her mandate is to investigate potential foreign interference with, and I quote, executive decision-making by Cabinet and its ministers in relation to their departments, including indirect foreign interference with ministerial decisions when such decisions are based on information originating at a lower level of government, covertly influenced by a foreign state or its proxy agent, etc. That close the quote. I'm not sure why Justice Ogg's mandate is limited to a lower level of government covertly influenced by a foreign state. In the previous meeting of this committee, Mr. Jennis raised the possibility of a future Attorney General of Canada being in conflict of interest because he or she has benefited from foreign interference in his or her riding. My knowledge of China's United Front strategy around the world is that there is enhanced Chinese Ministry of State Security early targeting of politicians deemed likely to in future assume influential positions, such as Attorney General for Canada. Now, we know from a leaked December 2021 CSIS report how China's Ministry of State Security uses a 3 color-coded political interference tactics to gain influence over Canadian government officials here in Canada and those traveling to China. Blue referring to sophisticated cyber attacks on targets' computers, smartphones and hotel rooms for possible blackmail. Gold referring to bribes, Yellow is what CSIS described as honeypots. That's how China employs sexual seduction to compromise a target. Bill C-70 and existing legislation should go a long way to addressing this kind of concern. But I would put forward there are more sophisticated operations by the Chinese regime here in Canada and other countries that are more challenging for us to counter. For example, the former Australian Prime Minister Bob Hawke recalls in his biography that shortly after he retired from politics, he traveled to Beijing and met with Chinese leader Jiang Zemin, who told him, and I quote, "Mr. Hawke, China never forgets its friends. We want you to know we regard you as one of our best friends," end the quote. In the years that followed, Mr. Hawke took on several directorships and consultancy positions relating to China, which enabled him to achieve considerable financial success. Here in Canada, we observe former cabinet ministers, former ambassadors to China, people retired from senior roles in our foreign ministry who have assumed lucrative opportunities relating to China after leaving government. Government career options in law firms and businesses and other sectors with associations with business networks identified with the Chinese Communist Party would clearly not be open to those who are identified as unfriendly to China while in a position of public trust, because we know the Chinese regime keeps extensive files on all of us, so they know who their friends are. So a concern is whether Canadian officials, because of the very subtle Chinese influence process of implied future benefits after retirement for Canadian policymakers, which Bill C-70 cannot track, would perhaps not act on intelligence assessments they receive that would call for Canadian government action that go against Chinese interests in Canada immediately, but leave those perhaps for others to respond to for fear of being identified with actions the Chinese embassy would not feel well disposed towards. If I could just conclude, I would say from this that perhaps just as government officials cannot exploit classified information to serve personal interests after retirement and have to keep the secrets that they derive in the course of their service secret for life, perhaps we need to restrict public servants from receiving benefits from foreign entities for life as well. Thank you, Mr. Chair.
Thank you. We'll go now to Mr. Kempa to make an opening statement of up to 5 minutes. Please go ahead, sir.
Okay, thank you very much, Chair McKinnon and members, for inviting me. I would just begin by saying that overall, the very large bill, which touches on the constellation of laws that govern Canadian national security, is very complex and welcome. The amendments, I understand, are quite urgent. There is a desire, perhaps, to have certain measures in place in time for any election that may come in 2025. Some of the easier reforms certainly could possibly be achieved in that time frame. I'll flag some of them that are perhaps a little bit more complicated, that raise more concerns that may render it more difficult to implement some recommendations in time for that potential election. The three main prongs of reform to the CSIS Act, amendments to other areas of national security legislation, and the creation of a foreign influence transparency registry are obviously the three main dimensions of reform. Most of what I'll have to say relates to the CSIS Act itself, being as that's one of my areas of major expertise as opposed to the others, although I will raise a couple of issues on the second two categories. So with respect to CSIS Act reform, I would regard it as very appropriate that CSIS now be able to pursue foreign intelligence virtually stored beyond Canada's borders. Wider ability to secure information from third parties, notably telecommunications companies, through streamlined procedures is very welcome. All of this coming through streamlined applications procedures for less invasive warrants being very welcome. As I read it in the bill, probably a good balance for ensuring civil liberties on those sliding scales of pursuing warrants in an expedited fashion. The key new ability for CSIS to share threat intelligence with other levels of government beyond Ottawa, including Indigenous governance bodies, with private sector institutions and the university community, is indeed extremely urgent, fortunately very easy to legislate, which means that it could possibly be done in time for CSIS being able to advise other bodies around any election in 2025. However, more difficult to implement in practice once on the ground. So I'd merely flag for you that CSIS and its new partners will have to figure out how best to share this new intelligence, what the thresholds for sharing of intelligence with a wider variety of partners ought to look like, not only because of CSIS's culture, longstanding culture of being reticent with the sharing of information, but also many partners simply not yet being skilled in weighing the value of and so putting into action different types of intelligence. So perhaps these types of issues could be addressed through regulations, developed through public safety or foreign affairs, and with CSIS's oversight body to guide CSIS in the development of those protocols. It's very encouraging, in particular, given that this bill is understandably, although large, does not address some of the broader thematic issues around CSIS's mandate, CSIS's relationship with other agencies such as the RCMP, whose role in national security is itself evolving and certain to be significantly reformed over the course of the next 5 or so years. So the automatic requirement for review every 5 years of the CSIS Act is extremely important and welcome, and leads me to read this bill in terms of, are we not putting in place anything that could frustrate some of the broader reforms that may be coming down the pipe in 5 years' time? So fortunately, there's not many areas that appear to lay barriers to bigger questions that may come up, but there are a couple of areas where we may not want to tie our hands, which I'll briefly touch on before I close my 5 minutes. I would encourage you to read your reforms to the CSIS Act as part of a triptych of legislation, as it was in the 1980s, where the CSIS Act, Emergencies Act, and RCMP Act were all drafted with reference to one another, such that in this piece of legislation, we have not revisited the question of the mandate of CSIS overall, the connection of the CSIS Act famous Section 2 standards for whether or not CSIS gets involved in anything, to the standards for invoking the Emergencies Act itself. This is probably wise to leave the Section 2 standards as they are in this legislation, for the reason that that second set of issues will be certain to come up as we have decisions from the Federal Court of Appeal on whether or not or what exactly the Section 2 standards for the Emergencies Act entail, on future lessons that will come from the OG Commission's review added to the Rouleau Commission's insights into the Emergencies Act, ongoing work of NSICOP and NSIRA into the future of the RCMP and so forth. So leaving that open is very wise at this time. However,
Could you wrap up quickly, please?
Pardon me, sir?
Could you wrap up, please?
Yes, certainly. As we get to the CSIS Act review, a key question will be whether or not threat to the security of Canada can include economic disruption as a form of violence that could pose a threat to the security of Canada. So very briefly, the two areas of concern that may tie our hands into the future, creating offenses, criminal code offenses relating to interference, any type of offense beyond terrorism committed in service of a foreign entity. You may find hurdles there if you have very minor offenses, such as summary offenses committed for a foreign entity that could lead to similar severe penalties to major indictable offenses. And finally, on the transparency registry, it seems that the country-agnostic approach is one that might prove difficult, in that you would bring a very wide range of countries under the attention of an agency that potentially could not monitor all of that information. I understand the desire not to create a series of, like a list, a permanent list of blacklisted countries, but a potential solution there is to allow for regulations where the ministers, in cooperation with CSIS and its oversight body, may produce periodic lists of countries of concern that could change with time. Thank you.
Thank you. So we'll start our questions with Mr. Caputo. Mr. Caputo, go ahead, please. 6 minutes.
Thank you, Professor Kempa. Mr. Burton, if Mr. Kempa, if there's anything you were just dying to get in that you left out, here's your chance.
Oh, no, I think I've covered it. Anything that would come up in questions, I'm sure we could elaborate
Certainly.
on.
Well, I have a potential couple of questions, but I'm going to turn to Mr. Burton first. Now, you had highlighted relations with China in particular, but I'm concerned with all sorts of relations, as we all should be, when it comes to foreign interference. And you had mentioned a color coding system, and you had said this bill goes a long way to addressing this type of interference. Do I have that right?
Yes.
Okay. Can you expand on how and why that is?
Well, I think that the main thing is it empowers CSIS to inform people when there seem to be potential issues involving conflicts of interest for certain significant people influential in the decision-making process. And I think that's a very good thing.
Okay, so let's take Mr. Jennings isn't here. I mean, he's a lot of places. Right here isn't one of them right now. He will be joining us later, I'm sure. Now, let's take his example where he had spoken about the Attorney General, for instance, and I assume this would be like what positive impact would Bill C-70 have based on what you just said, the information sharing or the ability to alert?
Well, I think the people that have to be alerted are the people who are potentially the subjects of this. I have an example of a young friend who was running for office in Saskatchewan, who, I calculated was being engaged by potential agents of the Chinese state, proxies of the United Front Work Department, where they were offering him things and extensive praise. And I said, that this is how they start. They see him as an up-and-coming young man who may, in fact, someday be serving in our parliament, and they would like to cultivate good relations and possible sense of obligation to him. And I said, just be careful. In fact, he'll be speaking to CSIS about what happened. I think it's just a question that people don't know when they're subject to a sophisticated engagement by the very many agents of the Chinese state who are operating in our country.
Well, that's an interesting point. People don't even know. I mean, to me, the question would be, well, why isn't there training on this, that type of things? And obviously, as parliamentarians, as elected representatives, people should be aware. But from what you're saying, it's much more insidious, maybe surreptitious, that people may not even know it's occurring. Is that accurate?
Yes. I've spoken to someone who was central in the development of the Australian Foreign Influence Transparency Scheme Act, and he said that, perhaps the act is not drafted very well, and perhaps the government of Australia has not allocated the resources to their security intelligence agencies to follow up on the act. But simply the existence of the act is a consciousness-raising device. And so I think a lot of people who, might have been inclined to accept some sort of going easy on China in anticipation of future benefits will now be aware that, this is something which will not reflect well on them and makes them complicit in the Chinese regime, including all of the espionage and foreign subversive activities and genocide that regime is characteristic of. And so, I think the fact that we're talking about this is already a very positive thing in terms of raising people's awareness that they just shouldn't let the Chinese regime start to make them beholden to a regime which is hostile to our interests and is engaged, as General Eyre has said, in hybrid warfare against us already.
Thank you. Professor Kempa, how much time do I have, please, Chair? A minute and a half. Okay. Now, Professor Kempa, you had spoken about the country-agnostic nature of Bill C-70, which is something that, at first blush for me, I would be supportive of. Now, one of the reasons I suppose we would deal with that is we have a changing world, and different governments are going to have different mandates. Is there a compelling reason why we wouldn't apply the same standard, and a high standard at that, when it comes to transparency and the registry of any foreign agent?
I think the only reason has to do with capacity. So if you were to establish a registrar's office that would be responsible for maintaining the database and some information on the activities of all of the those seeking to impact Canadian policy and so forth, and outcomes in a legitimate fashion, the amount of information would simply be overwhelming, to the point that it would, a senior colleague of mine, Wesley Wark, refers it has the potential to develop into a form of almost security theater, where you have an office that exists that simply by trying to watch agents from around the world cannot. The idea being that if you were to focus your attention on updated and rolling lists for which there was evidence to suggest we should be focusing on certain regions, you would have more capacity in that institution.
Now, that could be addressed through regulation, obviously. Yes. Okay, I think my time is probably up. Thank you. Thank you both.
I go now to Mr. Moff for 6 minutes.
Thank you, and it's a pleasure to be back at the Public Safety Committee for a little bit. Thank you to both of our witnesses for being here on this really important piece of legislation, and Dr. Burton in particular, I want to thank you for bringing your expertise. I think when it comes to China, you'd be hard-pressed to find anybody else in Canada that has your level of expertise on this subject. So you had mentioned working with Australia, but I wonder if you could compare Bill C-70 to our Five Eyes partners and how it compares to the legislation that they have in place dealing with foreign interference.
Yeah, I mean, I would say one thing about country agnostic. I was invited down to the U.S. Congress to talk about Canada, China, and I mentioned the possibility of this legislation, and the American Congress people were not entirely happy about the idea that we were going to be requiring transparency of foreign influence because, they're foreign in Canada too. I was a bit taken aback by that. I think what the real difference is in terms of the U.S. FARA is the degree of resources and implementation and effectiveness of the legislation. Australia has been slow to bring people to account. I think they just did the first one. They've had the Act in since 2019, but when the Act came into effect, for example, the former Australian Minister of Trade and Investment, who had been responsible for shaping the China-Australia Free Trade Agreement, which we did not regard that highly in terms of when we were thinking of doing free trade with China, and who negotiated a 99-year lease on the port of Darwin, Andrew Robb, that we subsequently found out had been being paid almost $800,000 a year by a Chinese billionaire associated with the Chinese People's Political Consultative Conference, which is the #1 agency for United Front work in China. He resigned from that consultancy just before the legislation came into effect. And we saw some other Australians who did that. So we might see a similar impact in Canada of people that decide that they'd rather not be associated with potential Chinese association. And I think Mr. Robb, suggested that it was really the political pressure that caused him to resign. There's no suggestion he ever did anything that was against the law or anything like that. So I do think it's a question of how enthusiastically we decide to implement this legislation more than the legislation itself, and the extent to which we provide the resources necessary, and including to the Foreign Influence Commissioner, and the nature of the regulations that we decide to put into effect, and I guess who the government decides to appoint through Order in Council to that role. So, the legislation's one thing, but making it work is something else.
Professor Kempa, did you want to add anything on that?
The point that I would add on implementation capacity would be, again, it is essential and important to clarify in the criminal code issues around, or create criminal offenses around foreign interference related to the protection of, for example, essential infrastructure, update definitions of sabotage, etc. But then the issue comes down to, if CSIS and others are able to amass information or intelligence that might guide criminal investigation, you would need an RCMP that has, or some other federal policing service that has the capacity to actually carry out those investigations to produce evidence for criminal prosecution. So this is the necessary first step, but at the moment the implementation would be quite difficult in that it's clear the RCMP does not have that capacity.
Thank you. I think I've got a couple minutes left. You mentioned resources and regulations, Dr. Burton, and I think, well, you both mentioned resources actually, and having the legislation is one thing, but how critical is it that the government puts resources behind this legislation to make sure that what we put in place, because I think all parties have agreed to fast track this bill. We recognize it's a priority, but how important are those resources to be attached to the legislation?
Well, I mean, obviously we need to, we need the security agencies and the RCMP to regard this as a priority area. But it's very difficult politically because people who may have found themselves beholden to the Chinese state for whatever reason, whether it was something they did in China or China knows something about them, are not going to be supportive of the idea of this information coming to light. So from the point of view of the investigation agencies, and I think Mr. Kempa would know better than me, do they want to take up a case that's going to be controversial and cause kickback from the people that they are, important people in our government who may, in fact, be needing some guidance with regard to whether or not they're fully supporting Canadian interests and are not being partially compromised by the interests of a hostile foreign state. So, it's not going to be easy, and I think the role of the commissioner will be quite critical. And I do have some concerns about the nature of that appointment as an order in council appointment and the provisions in the Act that allow that person to be removed at any time by the government. I don't know enough about the mechanisms of government, but I'd really prefer that there be a very high degree of independence to such a person.
Thank you. I think that's my time. 6 seconds. Professor Kempa, do you want to quickly add anything onto that?
No, just to absolutely echo that point on the importance of the independence of that office. Almost perhaps considering a type of tripartite governance structure for that body similar to the direction that the RCMP is very slowly moving in, with the establishment of a management advisory body, which is not currently formally an oversight body, but may become one, a civilian oversight mechanism for the RCMP. Something similar for this office might be appropriate to sort of insulate it from government influence.
Thank you. C'est maintenant Monsieur Ville.
Now the turn of Mr. Villemur for 6 minutes. Thank you, Chair. Mr. Burton, you spoke about people who are recruited potentially without knowing it, useful idiots, if I can use the expression, and some over the course of their career or even sometimes after their career. Do you believe that it's important that we set limits on the mandate of public servants, and do you think such an idea would be applicable and useful?
I mean, I've made this recommendation that really, if you served in government, you shouldn't be allowed to take money from a foreign power in retirement. And, when you return to the public, to the private sector, and, so many of our people, they're leaving foreign affairs in their 50s and they feel that they never got rewarded enough and they want to make big money. And we're seeing a number of my friends from my years in diplomatic service who, in fact, have left government and are working for China-related associations. So the issue really would be that, if you, while in a position of public trust, were identified by the Chinese government as not being friendly to China in some kind of way, then you would be toxic for a wide range of Canadian law firms, businesses, and boards that would not be able to hire you for fear of alienating the Chinese who, we know that they do this. I mean, we know from Jenny Kwan, for example, when she's not able to go to normal events in her riding because the Chinese evidently don't like her and don't want her present. So I think from that point of view, we have to accept the reality that it's very hard for people not to be tempted to go easy on China while in public life because they have half a mind to what they're doing afterwards. I'm not suggesting that it's that they have this all planned out, but I think it could be a somewhat unconscious thing of not shaking the Chinese tree. I don't think that we have a situation where, say, the Chinese ambassador goes to the Canadian foreign minister and says, if you if you take it easy on our Ministry of State Security agents operating in your country, we'll do good things for you when you leave office. It doesn't work that way. It's a much more sophisticated process of we just know that this is how it goes, and there are just so many examples that seem to me. I don't know what the word is, but it just seems it's an awfully coincidental that people that seem to give China an easy time or support Chinese purposes, people that say supported the immediate release of Meng Wanzhou, after they leave public service, find themselves being very successful in China business, even though they'd previously had no business experience.
Vous avez mentionné l'indépendance du.
You mentioned the independence of the commissioner. The bill would suggest that the commissioner is independent and that they can undertake investigations at will. However, the commissioner is responsible to the public safety minister and does not benefit from a task force as recommended by Mr. Kempa earlier. Do you believe that the independence as it's currently written in the bill is sufficient, or do we need to go further to ensure that there's full transparency and confidence of the public?
I'd like to see it more independent. I have some concerns about the conflict of interest commissioner, on similar sorts of notions. I think it's hard for people who are answerable to the government to investigate the people that's in effect their boss. So, but as I say, I put this out there. I don't understand the mechanism, the possibilities for ensuring greater independence, but I would like to see the commissioner pretty independent, and the provisions for removing this person be subject to a transparent and open process, so that if they're getting too close to sensitive issues, that they won't be removed, so that they can't find out things that the Canadian public has a right to know about.
Merci. Monsieur Kempa, sur l'indépendance.
Thank you. Mr. Kempa, on independence, the same question, please, the independence of the commissioner.
It's absolutely the case that serving at the pleasure of a minister for any head of a major policing or security organization is troublesome, not necessarily in the way that commissioner lacks the integrity or ability, the personal ability to stand up to their minister, simply on the point that they will tend over time to, they call it managing with one eye upwards, in the sense that you have to anticipate the wants and desires of your minister, sometimes against the interests of your organization. So the RCMP is the best example of how that model is troublesome that exists. If there wasn't a sort of a tripartite arrangement, if there was at least very transparent and clear information exchanges, if the commissioner were to be dismissed for questionable grounds, at least there would be public awareness and potentially outrage for an egregious dismissal.
Le projet de loi mentionne que le commissaire devrait.
The bill says that the commissioner would be appointed after the parties had been advised, but there's no formal acquiescence. Is that enough that the parties are just informed?
I would prefer a more perhaps a deeper process other than the one listed here. I'm not quite sure, other than, again, a tripartite situation where there's some advisory body, as there are with police organizations, for the naming of chiefs or commissioners, apart from the RCMP, where they're not simply picked by a minister through a process along those lines.
Merci beaucoup.
Thank you very much.
Thank you, sir. We go now to Mr. McGregor. You'd think I'd know by now. Mr. McGregor, please go ahead, 6 minutes.
Thank you. Thank you very much, Mr. Chair. I'd like to thank both of you for being here today to help guide us through this study of a very important piece of legislation. Professor Kempa, I'd like to start with you, just going to the Clause 34 of the bill, which is giving the new disclosure rules to CSIS. I can read very clearly that all of the following conditions have to be met before it's disclosed, but I too have questions on how the service is going to make decisions, and more importantly, what the receiving entity or person will do with that, because it's intelligence that is being shared, but then I guess the questions arise, what is the person expected to do that? Like if an organization I know there's protections for personal information, but if an organization was told by the service there's someone in your employee that we have concerns with, what are you then supposed to do with it? Is there anything that you could elaborate on to help guide this committee? Does this section need some amending, or as you said, would you like to see some clarification in regulatory making authority?
So, to my mind, it would actually be impossible to legislate, for example, a precise list of how exactly CSIS is meant to share every form of intelligence on a scale of most to least reliable with every possible public, private, and civil body that now can. Rather, I would see it as falling within regulations, and they would be more in terms of guidance for CSIS rather than a prescriptive list. Depending on the nature of the intelligence, you would almost have to imagine a situation where, if there is an entity like, for example, a university or a corporation, they would have to have basically an employee or designated office to receive intelligence information, and perhaps in exchange for working with CSIS, they would have to submit basically what their information management plan is to become a formal partner ongoing.
Yeah, and to be clear, I think this is a good thing that we're doing to allow disclosure of information. It's just more questions arise. We just want to make sure that it's done correctly and that the sharing is actually going to lead to a fruitful outcome, like it has a positive net impact instead of leading us into more rabbit holes by accident. Moving on further of the bill, there's quite significant amendments to the Security of Information Act in this legislation. And I'm thinking specifically on Clause 53 of the bill. Clause 53 of the bill, is roughly 5 pages long. In the existing Security of Information Act, Section 24, it does say that no prosecution shall be commenced for an offense against this act without the consent of the Attorney General. But in Clause 53, specifically, there's a section about political interference for a foreign entity. And given that the Attorney General ultimately is someone who was elected to the House of Commons and then appointed to Cabinet, I'm just wondering, are you comfortable with that section needing the consent of the Attorney General, or do we need to inoculate it to a more permanent member of the civil service who is not elected and not swayed by political events? Do you have an opinion on that?
So on that one, it's obviously, it would be the standard conventional practice to rely on the Attorney General, but I understand the reservations there. I would say, as long as there was some measure of transparency or accountability, such that if an egregious decision were taken, that there could be some form of action or remedial action, then that would probably be preferable to allocating it to a professional public servant, for example.
Thank you for that. And Professor Burton, I'd like to turn to you because, as you said, most of your comments were directed to Part 4 of this. I've raised questions during our first meeting on this definition of arrangement. It's talking about being on the direction of or in association with. Those are two very different things. Being under the direction of, there's an obvious hierarchy. It suggests employment, suggests that someone is giving orders and someone is executing them. Whereas being in association with a foreign principal, that seems to be a little bit more open to interpretation. And I'm just wondering, with universities often being a nexus of the political world, the educational world, but also of sharing of knowledge with foreign entities, is there a risk that universities might have some difficulty with this in having to register, the free flow of information between countries? Do you foresee any dangers we need to look out for as a committee?
It is very troubling. I mean, obviously, universities have a mandate to create and disseminate knowledge. They don't have a mandate to protect our nation's national security, and they are internationalized. And so freedom of academic freedom does make it challenging for us to tell universities that they can't do this or that. And then there's the troubling reality of scientists of Chinese origin who have come to Canada and naturally have extensive networks within China. So are they going to be unable to get research funding because of these suspicions? I really don't know how we can square this circle unless we start to look much more carefully at the relationship between universities and the state. But we are perceived, I think, by our Five Eyes partners as being a weak link in the protection of dual-use technologies and sensitive research. And the Winnipeg's Labs fiasco has not helped the confidence of our partners in terms of sharing information with us. So I am troubled by this, and I do agree with you. I looked it over. I don't understand what those words mean either.
Thank you, Mr. McGregor. We start our second round now with Mr. Shipley. 5 minutes, please.
Thank you, Chair, and thank you, excuse me, for the witnesses for being here today. I'd like to start first with Mr. Kempa, if I could. In your opening remarks, you mentioned that C70 was a good platform or a basis to get started on with this, and I tried to scribble down quickly what you had here, or what you said here, sorry. You mentioned that there was definitely a lack of RCMP capabilities to investigate, and that really needed to be built on, or really this legislation wasn't going to be that good. I didn't quite get completely what you meant there, and if you could really expand on that, I'd appreciate it.
Sure, thank you. I think that what I was getting at is that given that we have a 5-year requirement to review this legislation, it enables us to come back to some of the lessons that we will pick up over how well the institutions on the ground, some of which are significantly evolving their mandates, are able to enact or carry out what you have here. So in the 1980s, of course, the Emergencies Act, RCMP Act, CSIS Act were all written over a period of a couple of years with reference to one another. Obviously, CSIS being created from taking national security intelligence issues away from the RCMP. Given that there's an ongoing debate about the capacity of the RCMP to fulfill its federal policing functions, including investigations in national security, it's great if CSIS now becomes more effective at sharing information or intelligence with the RCMP, but if they're not in a position to carry that out, it will be very difficult. So there's an ongoing debate as to what the future of the RCMP will be. Will they carry on, and to what extent with contract policing across the country? Will they become two organizations with one principally focused on federal policing issues? We don't have the answers to that today, nor will we have them in a year. But what we have laid out here and how the RCMP manages its new responsibilities with CSIS sharing information could inform what's done with the RCMP Act in 5 years' time, for example, and the review of the CSIS Act in 5 years' time, taking into consideration what happens with the RCMP and CBSA, for that matter, and other partners down the line. So it's a learning basis here for what ends up working well and poorly for review in 5 years.
Thank you for that, and hopefully a lot of it works in the good way, not the poorly way. So, Mr. Burton, I have some questions for you. I had a whole bunch of questions here specifically on C70, but you've mentioned a few things that I just need to get a little more clarification on, or it's just going to bother me for a while. You mentioned that some of your colleagues have left to join other entities, and you mentioned specifically China. Could you give me some examples? Expand on that. What do you mean by that?
Well, there's certain agencies that are identified with promoting interests that favor greater engagement in Canada and China. So, the Canada-China Business Council, for example, the Asia-Pacific Foundation, the China Institute at the University of Alberta, are all institutions that enjoy funding, some of them from Chinese sources. In fact, the China Institute at the University of Alberta received 10-year sustaining funding from a Chinese billionaire who is vice chairman of the Chinese People's Political Consultative Conference, the University of Alberta will not say how much money or the terms of that funding, but one gets the feeling that if the University of Alberta's China Institute produced a report that was, say, supportive of this act, that funding might terminate. So, you have these very complicated relationships and interaction between people in the government and these agencies that are troubling to me. I mean, Senator Wu, for example, was associated with the Asia Pacific Foundation for quite a long time and continues to support their purposes in Canada. So I can think of 3 ambassadors who are working in China trade. I mean, obviously, I don't think there's any harm in my mentioning John McCallum as someone who, has been highly regarded by China because the Chinese have said that in as many words, son of China, I believe they've referred to him as, and others that, I feel a little bit uncomfortable about the relationship. And then we have some cabinet ministers who also are working on things relating to China, which then causes me to wonder how they were performing when they were in a position of public trust. None of this, because we haven't got this commissioner set up yet, all of it is just smoke and mirrors. I can't condemn people. I think if anybody was doing anything illegal, that our RCMP would be pursuing it. But I just feel that there does seem to be a lot of Chinese influence in our country, which is why we have the commission going, and we need to root it out. And this legislation is particularly important in trying to maintain our security and sovereignty against a foreign threat.
Thank you, Mr. Shipley. We'll go now to Mr. McDonald, please. 5 minutes.
Thank you, Chair. I had to go to Dr. Burton for. I wanted just to touch base on the transparency issue that you addressed in your preamble, relevant to possibly foreign governments and individuals. Like, what's missing now or what should we be doing to enhance that level of transparency in Bill C-70, or is it appropriate as it is?
Well, I think that, there are clearly a lot of institutions that are pretending to be civil institutions that, in fact, we know from some of the leaked CSIS documents are, in fact, under the supervision of the United Front Work Department of the Chinese Communist Party. We know that those leaders, some of those leaders of some 100 and something numbers have been vetted by the Chinese embassy. And so one can assume that those institutions, to some extent, have a mandate to serve Chinese purposes, and they often have addresses which are the same as the so-called police stations that we are concerned about, where the Chinese government is engaging in activities off-site that probably are involving some degree of influence or espionage activities. So I think we need more transparency on that, and I think the commissioner can provide that kind of information so that people are aware when they're dealing with institutions that may have a function which serves the interests of a foreign state in addition to their social function. These are institutions that sign petitions in newspapers that support the Hong Kong national security law, or urge that Meng Wanzhou be released early, or other things that the Chinese government feels are positive and that probably most Canadians would feel are not in the Canadian interest. That being said, I think people have the right to have a political choice, and if their political choices correspond with the interests of China in Canada, that is well within their rights as Canadian citizens. What it really comes down to is, are they receiving funding or support from a foreign power? When you look at things coming up on the internet for elections, it's perfectly legitimate for governments to put together videos of politicians saying things they wish they hadn't said or doing things embarrassing. But if those videos are funded and supported by a foreign power, it's a different level of participation in our democratic process.
I think we're seeing that now with AI quite frequently. You also talked a little bit about the individuals on the other end of this question, and if someone is compromised and they're unaware of it, what should the process be, or what is the process for the administrative investigative on that end of it? How do they in layman terms, contact those individuals and ensure, or are those individuals compromised in their situation of, say, their workplace or what have you? Like, what is the process there now? What's the UK do as far as trying to eliminate those type of compromised individuals that aren't even aware that they're possibly under the influence of foreign state actors?
Well, the UK has done some, they've exposed an actor who was active in funding political candidates and sent round a message to all of the MPs warning them about this individual. And they also found that there were staffers in parliamentary offices that they believe are under the influence of China, and there's now legal cases ongoing about that. I mean, we know from the CSIS documents about staffers in our parliament and parliamentarians that CSIS regards as being under the influence of a foreign power. They may sort of half understand the implications of what's going on, but I think once we have this process in place and we have the commissioner, that this commissioner can make it clear to people where the lines are in terms of one's engagement with a hostile foreign power, and inform, I guess, maybe inform their boss that, your person may be providing information to a foreign power that you would prefer that not be provided to a foreign power.
It's time, Mr. Chair. 16 seconds. I just wanted to go back, Mr. Kempa, just go to you for a quick moment in regards to the function of CSIS now compared to what should be the function of CSIS after this bill is passed. What's just if you can quickly say, is it just based on resources, working closely with the RCMP?
It basically changes its role from being an entity that serves government to an intelligence agency that circulates essential information to all manner of partners. It's a fundamentally different role. So it's a capacity issue for sure, but it's also the purpose would have to require a shift in the culture of the organization.
Is that not happening now?
Well, certainly, yeah.
Okay.
So in a sense, this bill supports where CSIS is currently heading and has publicly stated that it needs to head.
Thank you, Mr. MacDonald.
Am I finished? Sorry.
If you wrap it up real quick.
No, I'll wait for another question.
Okay.
To more elaborate point.
Because we're here for your answers, not for our questions. So, anyway, Monsieur Villemur, 2 minutes et demi, s'il vous plaît.
Mr. Villeneuve, 2.5 minutes, please. So I have just 2.5 minutes. I'll ask the same question to both of you, and I'll ask for quick answers, please. Mr. Burton, the register in its actual form, could it have prevented the situation at the lab in Winnipeg?
Well, I mean, if the register showed that there were people that were responsible for the lab who seemed to have influence with China, that would be one thing. We are puzzled as to who authorized the presence of People's Liberation Army researchers in the lab and some students. I mean, no one, I don't want to get too political about this, but no one has been made accountable for what happened. And I'm also puzzled as to how the two scientists who, according to the minister, are still under investigation by the RCMP, were able to leave for China and continue to work in sensitive areas under new names. So, I mean, I'm just at a loss as to how this situation came up, and very disturbed about what it does for our reputation with other countries, and of course the damage of the transfer of technologies to the Chinese state, who may not be using them for good public health purposes.
Mr. Kempa?
I would just add to that I think the main value of a registrar's office that provides basically a map of the agencies or networks involved in legitimate influence is that it provides CSIS, police, and other investigative bodies with a starting point for some of the darker networks that might be beneath that map. So it's in very many cases a starting point of investigation or intelligence gathering, where they have some idea of who they could at least start asking questions of to seek information.
Croyez-vous que les scientifiques auraient été inscrits au registre?
Do you believe that the scientists should have been on the register?
They're not for their clandestine purposes, but what I'm saying is perhaps some other body, such as a university office or other, that had been in any way related to the exchange of laboratory information between Canada and China would have been an agency that CSIS or a police organization could have asked questions of to get started on an investigation earlier.
D'accord. Vous avez parlé plutôt de la révision 5 ans.
Earlier, you talked about the 5-year review of the law. The Privacy Act and a couple of other acts have similar things and haven't been updated in many years. How do we make sure that it's actually done every 5 years and done properly?
Again, I don't think that can be specified in legislation. I simply think it's for the development of protocols through basically getting started and keeping track of best practices that become formalized in the working manuals of those organizations over time.
Merci beaucoup.
Merci, monsieur. We go now to Mr. McGregor. And in my defense, I used to work for a fellow named McAllister. So I'm 2 minutes and a half, please.
Thank you, Mr. Chair. Maybe I'll have a pseudonym one day as Gregor McAllister, and that would confuse everyone. Professor Kempa, when I was reading through this bill, everything seems to flow and make sense to the title of the bill and what it is aiming to do. The one section, though, it seems to stick out to me as being an odd place to fit it in are the amendments to the criminal code. So I'm talking specifically Clause 60 and Clause 61. There's an update to the sabotage section of the criminal code. And I note that the government, in drafting this bill, did insert 2 sections to, where it's for greater certainty it's not an offense if it's a protest, advocacy, or dissent. But I'm just wondering, in your review of these amendments to the criminal code, do you have any opinions on them? Are you satisfied that they are in good order?
So, of course, the main concern there is that some way or another, those powers could be used to somehow police or lay charges for legitimate domestic protest. It's disruptive to essential infrastructure, basically. I would just think that the provision that the protest must be significantly driven or influenced by or caused by foreign interference is the safety valve mechanism there. I do find that perhaps that language could be accentuated, that the action against essential infrastructure must be motivated for serving a foreign entity.
Thank you. And very quickly, you've heard my concerns with the definition of arrangement in Part 4 of this bill, the new Foreign Influence, Transparency, and Accountability Act. Just in terms of association, do you have any thoughts on that term being in association? Is it quite clear to you, or do you think this committee needs to do work on that?
So that is the one term where I think there's a need for work on that terminology. It's very, very broad, and most of the civil liberties critiques have focused in on that precise terminology.
Thank you.
Thank you. We'll go now to Mr. Keurig for 5 minutes, please.
Thank you very much, and thank you to our witnesses. Appreciate the insight. I would ask, and I'll start with Mr. Burton and then go to Professor Kempa. You talked about that tension that needs to exist because somebody holding views is not necessarily the problem, but it's when it's a foreign state that is and there's influence in that process. So I'm just wondering, how do we square that circle, so to speak, to make sure that we can, in fact, have a framework that ensures that we are protecting our democratic infrastructure, research infrastructure, et cetera, while also protecting the freedoms and rights of Canadians, because there's a tension there. We have to make sure that we get it right. So I'd ask for your feedback, and if you have any specific suggestions about what that should look like in terms of the context of this bill, especially because there's such a tight deadline for amendments. Start with Mr. Burton.
Well, I mean, I certainly think that it's important that citizens of Canada should be serving the purposes of Canada and shouldn't have some remnant loyalties to a nation that their ancestors or themselves may have come from. And I do think that it's incumbent on us to have much more transparency in these matters. I mean, the Winnipeg lab matter, I suppose that the issue was that Professor Chiu was receiving benefits from China through these Thousand Talents programs and other arrangements with the Wuhan Institute for Virology that she was not open about. And I think that, in terms of for example, the issue with Kenny Chiu, the main problem was that we couldn't find out where the WeChat and other Chinese websites information was coming from. Was it, domestic political preference, or was it something coming out of Beijing? We couldn't get any transparency on the sources. All of the stuff was under pen names and on websites that we couldn't associate with any existing institution, which, of course, by itself is suspicious. So I do think that we just have to know. And of course, we haven't talked about this, but I mean, the point of this legislation is not to prevent people from taking benefits from a foreign state, but being transparent about it. And, that would be a choice of Canadians. I receive funding from different foreign governments that have engaged my consulting services. I am only too happy, if called upon, to make that publicly known.
I appreciate that. Mr. Kempa, quickly.
A quick addition would be for the constant emphasis of the term clandestine in the legislation. So it's not the issue of influence at all. Canadian citizen is democratically permitted to overtly promote the interests of another state. It's the clandestine piece and the disclosure of any interest.
So there's a comparison made with the Ethics Act, and I know that I hear from constituents often that are frustrated. I also sit on the Ethics Committee, of which this issue has touched it. There's that transparency piece that is so essential to make sure Canadians know about it. So then, at least if Canadians know about it, then they can make decisions accordingly. So is there? What should that mechanism in terms of transparency be? Should there be, bulletins, or is it enough to be on a list? Is it enough to make sure that, there's this coordination between different levels of law enforcement? What's the right level of transparency? Does there need to be more, or is what's proposed in the legislation, does it go far enough? And I have one more quick question if we have time.
Well, I think the legislation is good. As I said before, I think it's really the regulations that are going to be the key here. There's still a lot of things that haven't been fully explained, including, as you say, those, how do you define those terms? And shouldn't we have terms that are very clear in these things? But my own feeling is, with regard to receiving benefits from abroad, that there shouldn't be any privacy allowed, that you have to be completely forthcoming about any conflicts of interest because of foreign money. And I think if people feel that violates their privacy, it's easy. Don't take any foreign money, then you won't have to talk about it.
That's great. Anything to add, Mr. Kempa?
No. Simply that annual reporting on the part of the Registrar's Office, which would be picked up on media and whatnot, would be very helpful.
I appreciate that. Mr.
Thank you, Mr. Carrick.
Oh, is that time?
That's
okay.
We'll go now to Ms. Serwitz. 5 minutes, please.
Thank you so much, Mr. Chair, and I want to thank both of you for your excellent contribution so far. I'm not usually someone who sits on this committee, so I feel very privileged to be here. One of the hats that I wear is I chair a Canada-NATO Parliamentary Association, so I'm often with other NATO parliamentarians around the world. We often talk about foreign interference, and we talk about cybersecurity, and we also talk about disinformation. One of the things that we talk about is whether or not our national security intelligence units have the ability to be able to be transparent about attacks that might be happening, that they stop. So, for example, around disinformation, often it's a way of actually communicating to the broader public that something's actually taken place and that's actually been stopped. And so I want to get perhaps your take first, Mr. Kempa, and then Mr. Burton, if he has something to add, whether or not there's the framework that is right in place that allows CSIS to be able to provide that transparency to Canadians.
Well, CSIS currently, and with this legislation, would have the transparency to report on essentially successes in addressing disinformation campaigns. I mean, the only thing that I would say is obviously they wouldn't release details that would let other entities know that they're capable or where they've successfully, because then those entities would simply change their tactics and so forth. But, you know, as part of CSIS's developing culture to inform the public and report, there's no reason that they couldn't do so in general terms.
Okay. Anything to add, Dr. Burton?
Yes, I mean, I've mentioned this before in Parliament that, you know, compared to Australia, the United States, and Great Britain, our security agencies, up until maybe relatively recently, have been much less forthcoming about matters. You know, Mr. Vigneault said to the Oil Commission, the purpose of CSIS is to have secrets. Well, I hear what he's saying, but I think a sort of cult of secrecy may be going too far. And if other nations are able to be more forthcoming and provide more information about foreign interference and influence operations in legal, you know, their statement of claim in legal cases and so on, that Canada could start to do the same. But I defer to Mr. Kemp on this, but it seems it's a sort of cultural issue within our security agencies to be very much more reluctant than other nations to inform Canadians and Parliament about what they're doing.
Well, I think there's been excellent testimony today about the need for the culture shift. And this, you know, not only because of C-70, but I think just because of the world that we live in and the threats that we face. Mr. Kempa, in a number of recent articles, you have discussed the serious problem that foreign interference represents, particularly in local nominations. And of course, there's minority government underway right now. Lots of nominations are underway and will continue to be underway. So to what extent do you think Bill C-70 will be protecting the legitimacy of upcoming nominations in the next election?
So it helps directly in the sense that CSIS would be able to share information, obviously, with political parties across the board sooner, but also to work in partnership, for example, with Elections Canada. Now, obviously, Elections Canada does not regulate most of the details of nomination procedures, but certainly does in the area of finance, for example, financing of nominations. So that would be a significant step forward, certainly. The other issue around the leaky nature of unregulated nominations for foreign interference has to do with the Elections Act and the fact that parties follow private rules for nominations apart from finance. But this bill would be a step in the right direction in that sense.
Thank you. And then maybe my final question to Dr. Burton. I've actually had constituents in my own riding come to my office and say, Julie, I'm convinced that I am being monitored by the Chinese government. And the only place I can refer them to is our local police. And I think there's some division somewhere that's supporting them. So I guess maybe my question to you is, and this might be in protocols and in regulations, but is there enough of a framework here, particularly around for the commissioner, that if someone in public feels that they are being monitored, that they would be able to find an avenue to actually find someone who'd be able to help them?
Yes, I mean, I think that also came up with parliamentarians from the International Parliamentary Association on China, the IPAC. I received some informal information from CSIS in that regard. I didn't know about it. They, for whatever reason, that doesn't seem to be their common practice, they did approach me about this, and I'm grateful that they did. I don't know, I don't think I'm really equal to challenging skilled young hackers out of Shanghai trying to get my emails and telephone conversations, but I'm making my best effort to encrypt and be more careful. I don't see why CSIS can't tell you if they suspect that. They did not tell me who it was or why it was. They only told me when it started, and I took that information on board and tried my best to find out more about how to be more careful in my cyber communications.
Thank you, Ms. Zurwitz. And thank you, gentlemen, for your testimony today. It's been most helpful, and it will be a great help in us in moving forward with this legislation. So we'll suspend for a few minutes and bring in the next panel. Thank you, guys. I would like to welcome our witnesses for the second hour. We have with the Canada-Tibet Committee, we have Sherab Therchin, Executive Director. And let me start by apologizing to each and every one of you because I seem to have a problem with names today. We have with the Uyghur Rights Advocacy Project, Mehmet Tati, Executive Director. And we have with the World Sikh Organization of Canada, we have Balpreet Singh, Legal Counsel, and he is joining us by video conference. So I will now invite Mr. Therchin to make an opening statement of up to 5 minutes. Please go ahead, sir.
Thank you, Chair and committee members. I deeply appreciate this opportunity to speak with you today on the important matter of countering foreign interference. And I would like to thank everyone involved for taking this matter seriously and for the detailed process to develop countering measures. I would like to focus my presentation on the Part 1 of the Bill C-70 with reference to the review of the bill by Sarah Take and Hannah Taylor. While the review finds many of the amendments encouraging, it points a limitation that Bill C-70 does not propose the addition of a definition of transnational repression to any pieces of the legislation proposed to amend or enact. Defining transnational repression is essential to recognize and address the specific tactics used by the foreign states to silence dissent among diaspora communities. This repression can take various forms, including harassment, surveillance, threats, coercion, physical violence. Authoritarian states such as the People's Republic of China routinely use these tactics to control dissent and opposition beyond their borders. The PRC's transnational repression is a well-documented phenomenon affecting several groups, including the Tibetan diaspora. The Chinese Communist Party employs various methods to exert control and suppress Tibetan activism and identity worldwide. I would like to describe some of the key tactics here. One, surveillance and intimidation. The CCP gathers personal information on exiled Tibetans through cyber attacks, spyware, and by questioning relatives inside Tibet. This information is used to intimidate and coerce Tibetans abroad, often through direct threats or by harming their families back home. Number two, coercion by proxy. The Chinese authorities frequently threaten or harm relatives of the exiled Tibetans in Tibet to exert control over the diaspora. This method ensures that exiled activists are silenced or forced to conform to the CCP's demands out of fear for their loved ones. Three, infiltration and disinformation. The CCP infiltrates the Tibetan diaspora communities and organizations using spies and co-opted individuals to sow distrust, spread disinformation, and undermine solidarity networks. These activities severely disrupt the community's ability to organize and advocate for Tibetan rights. Four, economic and social coercion. Tibetan exiles often face economic and social pressure from the CCP, including blackmail and efforts to sabotage their livelihoods. Such tactics aim to destabilize the diaspora and reduce its capacity to support the Tibetan cause. Five, the need for a clear definition in the Bill C-70. Incorporating a clear definition of a transnational repression in Bill C-70 would enhance Canada's ability to combat such foreign interference effectively. It would provide a legal basis for identifying and prosecuting transnational repression activities, thereby protecting diaspora communities from foreign state harassment and coercion. With this, I would like to offer some recommendations for the Bill C-70. Recommendation number one, define transnational repression. Include a comprehensive definition of the transnational repression that encompasses all forms of extraterritorial control and coercion used by foreign states against diaspora communities. Number two, enhance surveillance and prosecution mechanisms. Strengthen provisions within the CSIS Act and Criminal Code to allow for robust monitoring and prosecution of transnational repression activities, ensuring that perpetrators are held accountable. Recommendation number three, support victims and communities. Establish mechanisms, including specialized funds, to support and protect diaspora communities, providing resources and assistance to those affected by transnational repression. And final recommendation, internal cooperation. Foster international collaboration to address transnational repression, working with allies to develop a coordinated response and share best practices. In conclusion, Defining transnational repression in Bill C-70 is a crucial step towards effectively countering the PRC's tactics against the Tibetan diaspora and other affected communities. By recognizing and addressing these activities, Canada can better protect the rights and freedoms of all its residents, ensuring a safe and supportive environment for those fleeing authoritarian oppression. Thank you.
Thank you. We'll go now to Mr. Totti for an opening statement of up to 5 minutes. Please go ahead, sir.
Thank you. Thank you, Chair, and thank you, distinguished members. I would like to thank for this opportunity to testify today about the critical and pressing issue that we have been advocating for nearly decades. It is countering foreign interference. As a fervent advocate for the Uyghur people and against Chinese Communist Party's ongoing genocide, foreign interference by the Chinese state has had a marked impact on my personal life here in Canada. Chinese repressive and innovative efforts to silence dissidents has attempted to shackle my activism and intimidate me into retreating from speaking out about the devastation of my family, friends, and my community. I have received numerous times threatening phone calls from the state police directly and messages, hearing the most vile things being said about my loved ones. As a Canadian, my rights to exercise free speech and assembly have been attempted to be curtailed by the Chinese government all the time. Bill C-70 is a heartening response by the Canadian government to my community's experience of transnational repression. Bill C-70 is a significant step forward in addressing foreign interference and protecting Canadian citizens from transnational repression. We talk about transnational repression because in personal level, we do not experience interference. We experience repression by hijacking our family members just for us to speak up in Canada. For that reason, and both Tibetans and Uyghurs, we use the term transnational repression. As a human rights defender, I do believe that the broader application and the coverage of the certain acts of transnational oppressions against human rights activists afforded by the proposed amendments in the Bill C-70 will allow for greater protection of full and uninhibited exercise of our democratic rights in Canada. The proposed amendments in Bill C-70 will foster a joint strength among us Canadians to effectively counter threats to the security of Canada and to safeguard diaspora communities in Canada and broadly. The expansion of information disclosure to anyone, not just a public official, if deemed to be essential in public interest, will allow for enhanced bureaucratic transparency. Enhancing CSIS's ability to carry out its important functions serves to strengthen Canadians' trust in the agency and its capacity to detect, prevent, and respond to threats from foreign agents, including those from China. Necessarily, Bill C-70's emphasis on international cooperation underpins a crucial and a powerful tactic in countering the global reach of authoritarian regimes such as China. I applaud for the proposed creation of a foreign influence transparency registry, which will enhance the effectiveness of protecting vulnerable diaspora communities, and the proposed appointment of a Commissioner of Foreign Influence Transparency. However, I am a little bit concerned about the absence of Bill C-70 in proposing the addition of specific foreign interference offense to the criminal code, nor does it propose that refugee espionage or online harassment or digital violence be criminalized. Further, given the limited amendments to the criminal code, there are deficient means for the victim of foreign interference to seek redress for the impacts of transnational oppression. It is crucial that government go beyond interference activists carried out in relation to certain political and the government process in all aspects of Bill C-70. The Chinese government's reach extends far beyond attempts at directly interfering with Canadian institutions. My experience of transnational oppression is unrelated to political or governmental process, yet it is assault on my democratic rights, warrant protection as much as upholding the integrity of our democratic processes. Crucially, addressing foreign interference must take a victim-centric approach. Chinese transnational oppression and interference in Canada pose a significant threat to the Uyghur communities and the Canadian values of freedom and democracy. With the introduction of Bill C-70, Canada is making a strong statement against those oppressive tactics. It is imperative that we remain vigilant, stand in solidarity with those affected, and take concrete steps to counter these challenges. Thank you.
Thank you, sir. I now invite Mr. Singh to make an opening statement of up to 5 minutes. Please go ahead, sir.
Good afternoon. My name is Balpreet Singh. I serve as legal counsel for the World Sikh Organization of Canada, also known as the WSO. So the first week of June is a particularly somber time for Sikhs, as we remember the 1984 Sikh genocide and the Indian government's brutal attack on the Darbar Sahib complex and approximately 70 other gurdwaras across Punjab. I mentioned the horrific acts of June 1984 to remind committee members of the price that Sikh community members have paid due to state-sponsored violence, foreign interference, and surveillance, simply for practicing our faith. For the past 40 years, India has consistently sought to intimidate Sikhs in Canada and stifle Sikh advocacy for Khalistan, a sovereign state governed according to Sikh principles and values. This interference has included disinformation campaigns, visa denials, intimidation of family members, and as we know now, even assassinations. Discussing or promoting Khalistan is protected under freedom of expression and political discourse. Attempts to draw attention to ongoing Indian interference targeting Sikhs have fell largely on deaf ears, as India constantly maligns Sikh activism as extremism and worse. The Sikh community is currently at a pivotal moment in its history. In June 2023, Bhai Hardeep Singh Nijjar was assassinated while leaving the Guru Nanak Gurdwara in Surrey, where he served as president. The community, including our own organization, the WSO, recognized that this was an assassination at the hands of the Indian state. This was later substantiated as information emerged of Indian plans to kill Sikh activists here in Canada and across the world. This weekend, I met with 2 Sikhs who have been given duties to warn. They've been provided no details on the source of the threat they face or any resources to protect themselves. In short, they feel that they're on their own, pretty much abandoned. Foreign interference has had deadly consequences for Sikhs in Canada. We believe more needs to be done to counter foreign interference. In that respect, Bill C-70 is a step in the right direction. I'd like to highlight the ability of CSIS to now disclose security information to any person or entity should CSIS deem it relevant. This would be a positive step. However, we're also concerned whether foreign consular officials in Canada might also be considered an entity. Also, India regularly supplies false and misleading intelligence about Sikh activists in Canada. There would need to be some sort of controls to ensure that this isn't further disseminated. We know that the framework for cooperation on countering terrorism and violent extremism between Canada and India is still active. We have grave concerns over intelligence sharing between Canada and India. Vigilance needs to be ensured so that new powers created by this legislation are used to counter foreign interference and not turned around against communities here. India has falsely claimed that Khalistan activism in Canada is directed by foreign state actors. Could accusations like that trigger the provision in this bill? The sabotage provision being added to the criminal code makes an offense to interfere with access to an essential infrastructure with the intent to, and this is in B, endanger the safety or security of the naval, army, or air forces of any state other than Canada that are lawfully present in Canada. Sikhs have often protested in front of Indian consulates, and the embassy here in Ottawa. The Indian embassy staff includes a military, naval, and air attaché. Last year, the Indian media falsely reported that the Indian embassy in Ottawa was targeted with, quote-unquote, 2 grenades by a Sikh protester, a story covered today in the Journal de Montréal. India's NIA, the National Investigative Agency, also filed charges against a Montreal-based Sikh based on these accusations. Could this new criminal code provision be used to stifle Sikh protests? With the short amount of time I have left, I'd like to highlight the reference to international relations between countries in Bill C-70. We're concerned that this language and provision could go against the overall purpose of the legislation. Judges are given discretion to not release records following a trial if they believe that doing so would be injurious to international relations, national defense, or national security. Additionally, Section 8231, Sub 1 of the Immigration Refugee Protection Act gives the minister the ability to intervene if they believe that matters could damage international relations. The reason foreign interference against Sikhs has gone unchecked for the past 40 years is the desire of successive Canadian governments to increase trade relations with India, and this has been at the expense of the Sikh community. A report by Sam Cooper and the Bureau revealed that CSIS had planned a major intervention in 2017 to dismantle Indian intelligence networks in Vancouver that were monitoring and targeting the Sikh community. According to this report, this operation was obstructed by the government, citing potential repercussions for Canada-India relations. Canada needs new tools to counter foreign interference, no doubt. However, our organization and the Sikh community fear that the international relations clause may be used as an excuse to ignore ongoing interference by India against Sikhs in Canada and might even create tools that would persecute Canadian Sikh activists. So that's my time, and I look forward to the questions you might have.
Thank you, sir, for your remarks. We'll start the questions with Mr. Jennings. 6 minutes, please.
Thank you very much, Chair. It's a real pleasure for me to be able to have these three witnesses in front of them. All three are individuals, and they represent groups that I've had a chance to work with for almost the entirety of my time as a member of Parliament. So I want to thank all three of you for the way you diligently inform us as legislators, and also for your work on many important issues. As all of you know, Conservatives have been highlighting the urgent need to pass this legislation. This Liberal government has done everything possible over the last 9 years to delay action on foreign interference, and we are concerned that given the delays we've seen, that they may want to avoid this legislation being in force in time for the next election, which is why certainly we have been pushing them around timelines for getting this done. This is a question for all three of you, and if you can answer it quickly if possible. I want each of your feedback on the information sharing provisions in this legislation. If CSIS is aware of a threat against an individual, there are obviously many advantages to CSIS being able to make the decision to inform that individual of the threats directly, and there's maybe the concern about potentially political decision-making if there's a political check requirement, that leading to an avoidance of information being disseminated. What do you think about the information sharing provisions? Are they adequate? Should they be strengthened? Quick response from all three of you, please.
It is important, and it has been a one-way street. Now at least we will have a chance to hear from CSIS, because a number of times we faced direct threat. And there was no warning, and almost we faced kind of the attacks, direct attacks by the people just following us by car. And in that circumstances, if there is a warning beforehand, and if there is the car just chasing us in our daily life, at least we could take some personal precautions or additional measures to protect ourselves.
I would just add that depending upon the level of seriousness of the information that is available with the CSIS, again, about the citizen, if the information is serious enough about if it is about an information that could possibly cause or help the citizen, prevent any danger to him or her, then I think the information should be made available or shared with the concerned citizens.
Yeah, I'll just add that this could potentially be a double-edged sword. So we definitely, as a community, need to know more when there are threats against members of our community. And right now, like I said, these individuals who have duties to warn are completely in the dark. They have no idea who's threatening them and what the level of that threat is. But on the other side, we also know that there's an open channel with this framework of cooperation between India and Canada, passing information back and forth. So is this information going to be potentially false information, often coming from India, going to be disseminated further as a result of this? And secondly, do foreign diplomats or other entities here in Canada count as entities with whom CSIS can share this information?
Thank you. A second question.
how will bad actors try to get around this legislation, and what could we possibly do to block those workarounds? One area that occurred to me is they might try to interfere through subtle pressure, discrimination, implied threats rather than direct threats. What do you see as being the likely response from bad actors, and how can we cut off those kinds of potential responses? Quick response from everyone again.
I think I would like to go back to my focus on the need to define the transnational repression. If the legislation does not involve a clear definition about the transnational repression, I think it gives an opportunity for authoritarian states like China to go around the legislation and really coerce diaspora community, including Tibetans, to do what they want to do. In the specific example of Tibetans, in recent years, there are cases of Tibetans applying for visa to visit Tibet, which is usually considered very difficult. So if you have participated in, let's say, annual Tibetan Uprising Day, which is on March 10, if you are a regular participant at the celebration of His Holiness Dalai Lama's birthday, most likely you won't get visa. But if you do manage to get a visa, and if you do manage to visit inside Tibet, and then when you come back to Canada, you'll be asked to gather information. You'll be asked to not attend those events that you used to attend anymore. So having that clear definition, and this is just one example.
Okay, probably about 20 seconds to each of the two of you on this.
The bad actors will always develop and explore the means and the ways to exploit this process. But the most important is how we protect ourselves, how we prepare ourselves. So this bill at least strengthen that process and give us some the tools to just combat against those the people who are just skipping this process or trying to make use of it for their own advantages.
Mr. Singh?
Yeah, so briefly I can tell you that India uses foreign-based or Canada-based proxies, and there's usually different layers. So in practical terms, often getting to where the orders are coming from is a challenge. Do I have a solution? No, I don't. But you're quite right that there are different layers, and often it looks like there's a Canada-based individual who's actually got different layers above, and finally you can trace that to India, but it's not straightforward.
Thank you, Mr. Jennis. Go now to Mr. Gahir. 6 minutes, please.
Thank you, Chair, and thank you to the witnesses for appearing. My questions are largely for Mr. Singh, Balpreet. So, look, as a Sikh, as a Canadian, I resonate with large segments of your opening testimony. I think when the Prime Minister stood up in Parliament last year and spoke on the murder of Hardeep Singh Nijjar, that was quite a moment for the community. And I know for you and for me and for other members of the Sikh community, that moment really confirmed what Sikhs already knew and felt, and many deep-seated fears were realized. I now find it very ironic that Mr. Jennis is showing concern for this issue, because I remember that moment where the leader the next day flip-flopped and said that I need more information to comment on this issue, and did not stand with the Sikh community. And when the debate happened in Parliament regarding that murder, the Conservatives did not show up. So it's quite ironic.
Point of order, Chair. It is unparliamentary to refer to the presence or absence of members for one thing, but I was sitting there for the entire debate. Okay, I have a point of order.
So, okay, point of order.
Yeah. Mr. Gahir is dead wrong about whether I've stood with the Sikh community. He should ask the witness whether I've stood up for the Sikh community, because I've said far more in defense of the Sikh community's concerns than he ever has, and I'd like him to withdraw his comments about presence or absence of members in the House, because he's dead wrong. I was there.
So wait, let me get that straight. You've stood more with the Sikh community than me as a Sikh? You're kidding me, right?
Mr. Gahir, let's not talk.
Look up interventions in the House.
Across from each other. Carry on with your questions.
So,
Mr. Jennis, please.
So, from your opening testimony, Balpreet, you spoke about the security sharing that's taking place under this bill. So, from my review of the bill and the legislation, and from as far as I am aware, this bill does not open up new avenues for security information sharing with foreign entities. It's largely for Canadian entities, whether it be government bodies or individual persons within Canada. and any sort of information sharing that's taking place is happening to frameworks that are already established. And you mentioned one of them, which is the cooperation agreement. I think that was established with India as well. And so, as far as I'm aware, this bill does not open up new avenues for that kind of information sharing. But again, we are going to have CSIS appear before us and the minister appear. So I'd be happy to raise these concerns with him and with CSIS as well. As for the information sharing, it's amongst government bodies. We've heard testimony where, CSIS is reticent at times to share information, so this bill will allow for more information sharing because different government agencies may have different pieces of that pie, and only when you put those pieces together do you get the full picture, and perhaps you reach that bar whereby you can move to the next step. I do want to say that from what I've heard from testimony and from witnesses and from conversations that I've had, we are generally a net recipient of information. And I think that's a good thing in the international framework. One of the things about this legislation is there's a requirement that Parliament review the CSIS Act every 5 years in order to ensure that CSIS's mandate and powers are consistent to address the threat landscape that they operate in. Does your organization support this review?
Yeah, so to touch on a couple of the points that you've raised. Firstly, we know that this channel is open between Canada and India. Now, India is notoriously bad when it comes to respecting human rights, and we've seen, the transnational repression that's taken place, including killings on Canadian soil. I appreciate if we can say that, it's been largely, data coming our way as opposed to the other way around. But having this channel available means that we can't control how it's used in the future. I mean, there's going to be other governments that come in, there's going to be other people who come in your place and others' place. So having this channel open is problematic. So that's my first comment. The review of after 5 years is absolutely essential. So there's so many things that we're trying out for the first time, including the registry. We're going to need time to see how it works. And then you're right, we're going to need to have a review to see if we can improve things or change things if necessary. So yeah, we're completely supportive of that.
Chair, how much time do I have? 2 minutes. Okay, great. From what I've heard from testimony, when you look at that cooperation agreement, large sections of it actually, and most of that information sharing is for immigration purposes, and it's for the security background checks that happen. So it's not necessarily the type of information that I think the Sikh community is worried about. I think it's largely been used for immigration purposes. Obviously, a large segment of the population in India wishes to immigrate out of India, and large sections come to Canada. So that security framework is used for doing those background checks. I also wanted to ask about just the foreign interference that the Sikh community faces over the last few years and over the last few decades. How has that changed under perhaps the current government of India?
So once again, touching back on your initial point about the intelligence sharing. The intelligence sharing framework itself names a number of so-called extremist groups. It names 2 Sikh groups that are, as far as I can tell, completely defunct. I haven't seen any actions by them. But when it was presented in the Indian media in 2018, it was presented as an intelligence framework network cooperation agreement to clamp down on so-called Sikh extremism in Canada. So that's how it was framed in India, and I believe that's how it's intended to be used by the Indians. Now, I'm glad that that's, what you're telling me is correct, that's not the way it's being used. But once again, just having this open and the wording of the framework is problematic. In terms of the transnational repression, under the Congress governments that we've seen in the past, the messaging has been very similar in terms of claims of so-called extremism, which is largely just...
Great, thank you. So I do want to say, Balpreet, that when the minister does appear and when CSIS does appear, I will specifically ask about that information sharing cooperation. Thank you.
Thank you, Mr. Gahir. We go now to... On y va maintenant, Monsieur Villeneuve.
We'll move now to Mr. Villeneuve. 6 minutes, please. Thank you, Chair. And I'd like to thank our witnesses, all of you for being here today. I'll start with you, Mr. Toti, and then follow with Mr. Churchin. You have actively supported a foreign agent registry. is the government's proposal in C70, does it meet your expectations?
As I said, it is the right direction, and it is the first step, and we have been trying to get some sort of legislative action on this because China has been very active, not in Canada, the many in our allies countries. And for that reason, some countries already took some actions. But in Canada, it took some time. And at least we have this opportunity, and there are a number of amendments required. And when we have something, we can improve it. And we look at this issue from this perspective because our communities, and one of our community members, Hussein Jalil, is Chinese jail since 17 years as a first victim of transnational repression. And for that purpose and the reason, we have one bill right now tabled, and we prefer to work on this bill, and with our suggestions and recommendations, just improve this bill down the road. At least we have to pass this bill as soon as possible.
If you could make one suggestion to improve the register, what would it be?
We should go one step ahead of what Australia and the UK has, or US has right now, because it is quite outdated. And so at least now we are working on this bill. And for that reason, we can study those, the countries' legislative provisions, and we can improve from their experience, and we can strengthen it.
Merci. Monsieur Turchin, même question, s'il vous plaît.
Thank you, Mr. Turchin. Same question, please.
I echo my colleague friend Mehmet Toti's point. I think the time is of the concern. We need to get this passed and be implemented before the next election. And we are part of a coalition that is actively working on the Foreign Influence Registration Act, with including activists from Hong Kong, Canada-Hong Kong link, Gloria Fang, who will be testifying, I think, in a couple of days here in the same committee. So I would defer to my colleague Mehmet Toti and Gloria Fang in the upcoming days.
Et si vous aviez une suggestion à faire?
And if you had one suggestion to make to improve the register, what would it be?
So again, with colleagues from Hong Kong leading this discussion, one of the points that was raised in our discussion is the definition of proxies in the Foreign Influence Registration Act. So that, I think, if possible, that needs to be, again, clearly defined.
Merci beaucoup. Monsieur Singh, même question, s'il vous plaît.
Thank you. Mr. Singh, same question, please.
Yeah, so I'll go back to the initial point I made, which is the fact that international relations can play a role, that needs to be, we need to take a look at that. So I know in England they have a two-tier system. You can pick countries of more concern, less concern. I don't agree with that approach. One more, I think, suggestion I would have is that the commissioner, the integrity commissioner, transparency commissioner, being a cabinet appointment, this could be a problem. I think we need to make the commissioner as independent as possible.
Donc, Monsieur Singh, je vais poursuivre avec vous.
So, Mr. Singh, I'll continue with you. You don't think that in the current form in Bill C-70, the independence of the commissioner can be ensured at a level that would satisfy you?
I think it would be better that if it were not at the whim of cabinet. Yes.
D'accord. Monsieur Toti, même.
Thank you. Same question for you, Mr. Toti. The commissioner's independence, what are your thoughts on that?
The commissioner should be independent, it is period, and should be in line with our democratic norms and accountability. And this is the part of the national security issue for Canada, and it is related to for our future generation. For that reason, we should keep this commissioner far away from political dispute and keep that person impartial. And for that reason, I think that is important to keep the commissioner impartial.
Est-ce que cette impartialité serait...
Would that impartiality be similar then to that of the Auditor General then, for example?
I don't know in the technicality how far we can go, but the impartiality of the commissioner is crucial.
Ça, c'est un fondement, là. Yeah. Une exigence.
So that's fundamental. Okay, Mr. Turchin, same question on the independence of the commissioner.
I think everyone is agreeing that the commissioner should be independent. Yes. I think this whole discussion on the foreign interference has involved a lot of consultations, various parties, stakeholders involved. So the idea of keeping Commissioner independent is very important for everyone, including for witnesses like us.
I think all witnesses have agreed that it is in the public interest and that we do absolutely need to act here. So in the part that concerns sharing of intelligence, do you have any suggestions, Mr. Toti?
The first time when the media reported about just a sort of unknown vehicles chasing or following me was in 2007. Now it is 17 years past since then. And the last year at this time, the one government official just who happened to be in the same occasion, and after I left that occasion, and he called me that 2 cars are just following you. And it is a direct threat for your safety and security. And so it is crucial that, because we are taking on China, and we talk about China, one of the most notorious and brutal regime in the world. And so Chinese government is deploying tons of ways and means just to attack us and silence us. And so if there is any crucial information that relates to our safety and security for our family members or back home, we should know, we should be alerted. That is crucial.
We go now to Mr. McGregor for 6 minutes.
Thank you very much, Mr. Chair. Thank you to all of our witnesses for joining us today as we take a deep dive into Bill C-70. I want to start with Mr. Turchin and Mr. Toti, because I was taking notes when you both made your opening statements, particularly with regard to the need for a definition of transnational oppression. And I'm trying to sort of figure out, if when we come to a stage where we're considering amendments, where we best fit this in. Because, this bill amends a number of different existing statutes and also creates a new one. But I just wanted to draw your attention to the fact that in this bill there are important amendments to the Security of Information Act. In this bill, there are going to be new clauses that are going to go after intimidation, threats, or violence that are committed on behalf of a foreign entity. There are going to be amendments that are offenses that if you commit an indictable offense on behalf of a foreign entity, if your conduct omits the fact that you are working for a foreign entity, but also if you interfere in the political process on behalf of a foreign entity. And a lot of these, in fact, all of them, have quite serious punishments associated with them. So I'm just wondering, and I invite you, if you want to submit a brief to this committee, that's great, that we can get later on. But is there anything missing in those that is not covered by what you want? Like what are we missing? Because that seemed to cover a lot of what you had said in your opening statement. I just want to make sure we're getting all our bases covered. So I'll start with you, sir.
I think the bill covers a lot of things. It is. As an activist, as a human rights activist, I find it quite encouraging, and I mentioned it in my opening remark. And also, the analytical reports that is submitted, I think, just yesterday by Sarah Tick and Hannah Taylor does mention that many of the amendments in the legislation is quite encouraging. Having said that, their analysis of the report points out, as I mentioned in my opening remark, about the lack of a definition of transnational repression. I think the common aspect here is, as you mentioned, the foreign entities is common in the transnational repression as well as in the foreign interferences. However, the differences, at least based on some of the available literature, seems to suggest that the target group is different for foreign interferences and transnational repression. In case of foreign interferences, the target group seems to be more of a state structure, whereas in case of a transnational repression, it is really the diaspora communities, such as Uyghurs and Tibetans. So that was the reason. But otherwise, we actually find it very encouraging.
And Mr. Chair, do you want to have a chance to?
Yeah. It is really important to have a clear definition because U.S. Senate has introduced one bill, which is S-831. It is called Transnational Repression Policy Act. That Transnational Repression Policy Act clearly defined what is transnational repression. And for that reason, the name and number of the definition of the offenses, but most of those definitions or amendments as a result of the consequential amendment, because when you add one thing and the related bills need to be updated consequently. So for that reason, we need, as part of this the important bill C-71, we have to clearly define what is transnational repression.
Thank you. And I did take note of your, you had a slight bit of disappointment that we weren't using that term in the criminal code, but I think given that the Security of Information Act is being amended in these ways, and there's some significant punishments, some of the punishments are up to life imprisonment, perhaps that's an area in this bill where the committee can look at inserting that definition. So we've noted that, so I appreciate your testimony. I want to save my last question for the World Sikh Organization. And just, Mr. Singh, with regards to your comments about the amendments to the criminal code, you had referenced that definition of sabotage and specifically endangering the safety or security of the naval, army, or air forces of any state other than Canada that are lawfully present in Canada. I'm just wondering, are you, there is a, if you read further down the bill, there is a section that says for greater certainty, and it says that, you know, no person commits an offense if they are participating in advocacy, protest, or dissent and do not intend to cause any of the harms referred to in that paragraph. Are you satisfied with that, or do you think this committee needs to establish better guardrails than what's already in the bill?
So I gave you the example of the Ottawa protest from March 2023. This was by all accounts a peaceful protest, but when you have accusations of grenades being thrown, how is that going to affect individuals who want to come protest? I mean, is this opening it up to basically foreign governments threatening or throwing the sink at these dissenting communities and hoping something sticks? And on the other side, even if you know you're going to be exonerated at the end, it just puts you in this long process and you just decide it's not worth the risk. So this is how I see a lot of things in this entire bill. They're double-edged swords. If they're used by foreign governments, for example, the Sikhs are a stateless people. We have networks in countries across the world. Now, when India accuses of being Khalistan advocacy of being directed by foreign entities, you know, is this going to cause us trouble here? I hope not. But what are the safeguards? This is what I'm confused about. I mean, this is intended to stop transnational repression, foreign interference, but will it be a wet blanket for communities like mine who are advocating for causes that foreign governments do not like, and they're willing to use all of their resources to stop?
Thank you, Mr. McGregor. We're going to start our second round now. This will be an abbreviated second round. We will end this round with Mr. McGregor. We will start with Mr. Jennings. 5 minutes, please.
Thank you, Chair. I do have to just respond a bit to Mr. Gahir's line of questioning. Liberals want to praise the Prime Minister's...
I have a point of order. Yep. So, Chair, the member opposite that's speaking right now, Mr. Jenius, earlier claimed that he's done more for the Sikh community than I have. On the House floor, we just wanted to do a quick search, and this member did not speak at all. When we had an emergency debate on the killing of Hardeep Singh Nijjar, this member did not speak. And he's claiming that he's done more.
The same point, Chair. I'll respond to the same point of order.
On the House floor.
This is debate. I don't want to get into the debate. We want to deal with our witnesses, get the information they have to offer us. So I recommend that you guys take this up offline. But I would encourage you to get back to questioning the witnesses.
The World Sikh Organization, the organization represented here, has actually done rankings on members of Parliament in terms of the volume at which they raise Sikh issues. I would refer the member to those rankings and how I performed in them if he wants to know how often I speak about Sikh issues in the House.
So why don't you
now, Liberals want to...
Nijjar, then?
Can I speak, Chair? Can you bring the member to order? Liberals want to praise the Prime Minister's public statement in the House, even though this Liberal government has done nothing substantively to combat foreign interference. Now, following the assassination of Mr. Najjar, I submitted an order paper question, Q2488, regarding information sharing between Canada and India. The government confirmed in response to that question that the information sharing agreement signed by the Trudeau government is still operating and information continues to be shared. I further asked in the same question if any information had been shared with the government of India regarding Mr. Najjar specifically before or after his assassination. I said in the question, was any information shared at any time between law enforcement or security agencies of Canada and India regarding Hardeep Singh Nijjar? The government refused to answer the question. They flat out refused to answer my question about whether intelligence was shared with the government of India on Mr. Nijjar. One would think that if the answer was no, they would have just given a no. So, Mr. Singh, I want to bring you into this conversation. Do you think it is inconsistent for the Prime Minister and for Mr. Gahir to make statements in the House on the one hand, but to refuse to answer questions about whether this Liberal government shared intelligence about Mr. Najjar?
I can tell you that the community much appreciated the Prime Minister's statement in September, and it was farther than we've seen any Prime Minister go. Are we completely satisfied with the record? As I said in my statements in 2017, according to the Bureau article, this network operating out of Vancouver that was targeting 6 was not cracked down on as a result of not wanting to endanger Canada-India relations. So these things have irked us for the past 40 years. But, I mean, credit where credit is due. The Prime Minister's statement was really a turning point for our community here. In terms of intelligence sharing, you're right. The entire community wants to know, was intelligence shared on Mr. Nijjar? We know that Mr. Nijjar was part of lists that India had sent to Canada on a number of occasions with absolutely laughable intelligence, so-called intelligence. Was anything sent back? I certainly hope not, but, if we can find that out, that would be great.
Yeah, I understand what you're saying. I mean, I think at a minimum, the government should answer questions from parliamentarians. And again, if the answer was no, a simple no could have been given. We submitted that question, 2488, and we haven't seen questions like that submitted from government members, and I wish they would do more to stand up for the various communities that they claim to represent. I want to ask our other two witnesses about point was raised by Mr. Thurchin about limits around traveling, fear of traveling, possible threats around visas being used as a vehicle for foreign interference. We've also seen the problem of people being rendered from third countries. This is the case of Mr. Hussein Chalil. And given how the government of China seeks to exercise dominance and influence throughout the world, not just within their own borders, rendering from third countries can be a real problem. Abuse of red notices and other such things. How can we combat these fears that people may have that if they speak out on certain issues, that they will be very limited in terms of their ability to travel, not just to China, but also to other countries?
You raised a really important and a crucial point, and I'm living in Canada since 1998, and so far I can travel the Western democracies. I cannot travel to Central Asian stand countries, for example. And Turkey imposed me a travel ban since 2004. And the number of other countries, for example, Malaysia or Indonesia and Pakistan and Egypt, and I would like to just go to Saudi Arabia. As a Muslim, I would like to perform my Hajj, the duty. I cannot go, and because the close relationship that Saudi Arabia forged with China, and they are acting upon Chinese requests at any time, and so it is quite a limitation for me.
I think one of the available mechanisms to deal with this, maybe this is not within the scope of this committee, but the principle of reciprocity, I think, is an important mechanism to solve this problem. I had a chance to speak on this in the Foreign Affairs Committee last year. The U.S. passed a bill on Tibet called Reciprocal Access to Tibet. So any Chinese officials, media, having access to visit any part of U.S., but same access should be available for American officials and media journalists, congressmen, senators. So similar legislation, if passed in Canada, the principle of reciprocity, and that if that could be extended to common citizens, I think would solve this problem.
We'll go now to Ms. Zaid. Ms. Zaid, 5 minutes, please.
Thank you, Chair. Thanks to all the witnesses for appearing before this committee on a very important issue. I'm glad that we are examining legislation on an important issue where the Harper Conservatives did little to nothing to address over a decade in the government. My first question is for Mr. Tohti. Mr. Tohti, thank you for being here, and thank you for your relentless advocacy for the Uyghur people. I know it has not been without personal cost. Last year, you told the Ethics Committee about threats you received in July 2020 before your testimony at another at another parliamentary committee. So could you please talk about that and other ways the Chinese government tries intimidate and silence people like yourself standing up for the human rights of the Uyghur people?
Thank you. As I said, since 1998, I have been living in Canada, and I'm totally isolated from my family members, and I didn't have any chance to visit my mother and all other siblings, and for them, I didn't have any chance to come to Canada and visit me because Chinese government blocked their passport application. So more than 33 years, it is total isolation. I'm alone here in Canada with my own family. And so, as I said, Chinese repression did not stop within its border, and wherever we do advocacy work in Canada or some other places, Chinese extended arms always hunt us. And just before a couple hours testifying before the committee on the Chinese genocidal policy, I received a very ugly message about my mother. And then just 2 weeks before the parliamentary vote on M62 for resettlement of 10,000 Uyghur refugees, I received a direct call from Chinese state police, just putting my uncle on the end of the phone and threatening me. A number of my family members already dead, and if you continue, you will face the consequence. That kind of the threat. And so last year again, before heading to the conference, the two cars chased, and it was the warning from Canadian officials at the Global Affairs, and we saved our life just because of changing our route. And so this threat is imminent and every day, and this bill in that regard just provides one tool, just combat against those foreign actors.
Thank you, and thank you for sharing what you have gone through. In one of the recent interviews in the Hill Times, you mentioned, most importantly, the legislation clearly defines foreign interference in the criminal code. So can you please speak to why this criminal code amendment is so important?
It means in our legislation or in our bill, there is a name for it, and there is a penalty for it, and there is consequence for it for foreign interference. And for that reason, it is important. Unless we define it, unless we criminalize it, unless we put a certain sanction on certain offenses, and we cannot do anything. And that is exactly, for example, there should be some provisions in our law for bullying or intimidation or harassment, but there's no clear definition, especially when it comes to foreign interference. Our law enforcement agency are helpless. With this law, there is a clear definition, and it is a criminalization of that offense, so at least it gives a tool for our law enforcement to act upon it.
Thank you. And how important is that we pass this legislation as quickly as possible in order to ensure full implementation prior to the next election next year?
It is extremely important, and it should be passed immediately because there are a lot of discussions have taken place about the importance of this bill, and we have experience. We already from our neighboring countries and allies, and they had a great deal of experience. And for that reason, this was the loopholes in Canada. We are trying to close it down. It is important that all political parties set aside their differences, just focus on this bill and pass it as soon as possible, and try to make it better down the road, because every 5 years we have a chance to review it.
Thank you.
Thank you, Ms. Said.
Thank you.
On y va maintenant, Monsieur
Mr. Villemule, 2.5 minutes, please. Thank you very much, Chair. Mr. Toti, you spoke earlier about independence, and when we look at the bill in its entirety, other than that idea of independence, what would allow you to trust the process? What would it take for you to be reassured?
The implementation is the key. The bill is important. For example, we signed the Canada, United States, Mexico trade agreement. In that bill, USMCA agreement, there is a provision to ban forced labor production entering North America. And the United States acting on that part of the agreement, but Canada is not. That's the reason we are not intercepting or seizing any shipments full of the products made by the use of Uyghur forced labor. In the meanwhile, United States is confiscating thousands of it. So implementation is key. How we can implement it? We have to strengthen the organization and law enforcement with the resources. Resources means human resources, intelligence, and other resources, whatever they need. And so unless we equip our organization or entity with a stronger the ability, capacity to implement this legislation, again, this bill will be on the shelf.
Oui, alors que les Américains poursuivent les gens pour...
Well, Americans are going after people for that. Here, we're still working on a bill, so yes, we're a bit behind. What is it enough? Bill C-70, is it enough? Or is there something missing?
Our organization, we worked, we advocated to pass the Transnational Repression Policy Act. It is a golden standard of that bill. And we didn't have that golden standard. So whatever we have, it is even silver standard, it is better than nothing. And so at least we will have a chance to review what is working, what is not, and amend it and improve it once in every 5 years. And for that reason, I'm optimistic. And for many Canadians, including our parliamentarians, foreign interference and transnational, it is quite a new terminologies.
Tous les outils que vous pourriez nous fournir pour qu'on nous...
So any tools that you could provide so that we could meet this gold standard would be welcome. Thank you.
Merci, Monsieur. We go now to Mr. McGregor for 2.5 minutes, please.
Thank you, Mr. Chair. I'll get an answer from all three of the witnesses. So in this bill, you know, its main purpose, of course, is to have transparency and to raise public awareness just of how foreign influence from foreign principles works to influence certain processes here in this country. One thing other witnesses have noted is that it is country agnostic, because it might also be a good thing for the Canadian public to be aware of how our allies are influencing us, because of course that happens. I mean, we have close friendships with many countries, but it's no secret that, you know, particularly with the United States, they have sometimes tried to influence how Canada adopts certain policies. That's a historical fact. Other bills have addressed this by drawing up a scheduled list, which would be influenced by reports from CSIS or NCCOP, but still subject to the Governor and Council adding certain countries. From each of you, what is your preference? Are you happy with this being country agnostic, or would you like to see certain countries focused on more than others? And very quickly from all three of you, please.
Certain countries should be focused more than others, because the certain countries has a mission, and they have a specific capacity with the resources to focus on Canada, just for to maximize their economic, diplomatic, or other interests. And for that reason, we have to focus on certain countries more than others.
Mr. Turchin?
I would echo Mehmet's point on this. I think the level of interference that China, the capacity that China has to engage in the level of interference, I think that calls for a separate focus on China. So with that regard, I would certainly put China in the focus of the overall arch of the foreign interference, just because of the capacity.
I'm
Mr.
going to have to take a different approach from my friends. I think it has got to be agnostic, because who's going to set the countries? And we've already seen, for example, in the foreign interference inquiry, the countries named were China, Russia, Iran. And in the proceedings, we found out that India is actually by far the second largest foreign interferer in Canada. And it was left out to further international relations. So this cannot be the way we approach foreign interference. And like I said, our community has been subject to foreign interference for 40 years unabated, because Canada didn't want to mess up relations with India. So it can't be the government that sets these lists. It's got to be agnostic.
Thank you, Mr. McGregor. So that brings this panel to a close. But before we suspend for the next panel, I'm going to ask the committee. The clerk has distributed on Friday, May 31st, a project budget for C70 in the amount of $53,250. Is it the pleasure of the committee to adopt this budget? Yes. Done. Thank you. Gentlemen, to all our witnesses, thank you all for being here today. Your interventions have been most helpful. And with that, we will suspend and bring in the next panel. Thank you all. This meeting back to order. So I would like to welcome our witnesses for the third hour, although it's been longer than that. As an individual, we have Michel Junot-Katsuya, former chief of the Asia Pacific Desk, Canadian Security Intelligence Service. For the Center of International Governance Innovation, we have Aaron Scholl, managing director and general counsel. And with International Civil Liberties Monitoring Group, we have Tim McSorley, national coordinator. Mr. McGregor, on the point of order?
Just very quickly, I know bells are going to ring soon. I'm just wondering if the committee can give unanimous consent to proceed through the bells part way so that we can carry on with as much witness testimony
I've had a discussion. I thought you were involved in that. There's an agreement that we should go to at least quarter two. Yeah? Good. Sorry, gentlemen. So I now invite Mr. Junot-Katsuya to make an opening statement of up to 5 minutes. Thank you.
Merci, Monsieur le Président.
Thank you very much, Chair, members of the committee. I'd like to thank you for this opportunity to share my thoughts and my recommendations on Bill C-70. I will be speaking in both official languages. At the outset, I'd like to share with you the basic ideas that are at the foundation of my analysis. A strong and healthy democracy must be protected by three fundamental ideas: transparency, accountability, and the independence of those who are in charge, free from any interference.
Of foreign interference has raged for nearly 2 years. What emerged, the extent to which there was dysfunction, scheming, and control games in the arena of foreign interference. Yes, we have been targeted by foreign power, but their work has been facilitated by actors in key position in our government, past and present, who have facilitated and even taken advantage of the situation for their personal and partisan game. To that effect, I will bring your attention the report that just been released by the Parliamentary Committee on National Security, who again blames severely some elected officials for willingly and consciously collaborating with foreign states. Hence, the need to recall the three basic concepts for protecting our democracy system: transparency, accountability, and independence, free of all interference for people in office. Bill C-70 is an opportunity to correct this error and manipulation in order to aim for a Kantian ideal of our system. Je n'ai eu que 48.
I've only had 48 hours to prepare my formal presentation, so I'll quickly mention a few key observations. My concerns primarily lie with the implementation of the proposed reforms. First of all, I welcome the proposals to extend CSIS communications to organizations other than the Prime Minister's office. Now, if we want to talk about a real national security program, we need to include the provinces, and we need to make sure that they have national security advisors for premiers. They're already being targeted by foreign agents, and they're totally unaware of it.
The effort to clearly define criminal actions by taking agents acting for the benefit of foreign powers. However, I fear in the execution, because to successfully contain the problem, the RCMP and CSIS will have to collaborate. Unfortunately, history tells us that since its creation, CSIS, out of concern and formal instruction received, and I was there when it took place, received right at its outset not to testify ever in court or to prevent to go to court as much as possible, which led to intentionally obstruct the RCMP investigation. This happened in the files of Air India, Ahmed Drassam, Sharkawi, and Jeffrey DeLille, to name only the few that are known publicly. So it is normal to fear the system will reproduce the same deficient mechanism. To support that apprehension, the director of CSIS, Monsieur Daniel Vigneault, testified before the Commission on Inquiry to Foreign Interference that he had, on 2 occasions, following a meeting with the Prime Minister, modified the reports to accommodate this last. This clearly demonstrates that our national security do not have the necessary and desired independence. Dans cet ordre.
So, continuing in this vein, I would remind committee members that all prime ministers, from Mr. Mulroney to Mr. Trudeau, have been aware of the problem of foreign interference, and all of them have chosen to ignore it for personal or political gain. This systemic problem is not new. Once again, there's a problem of intelligence control and of accountability. I'll continue with my remaining time with my analysis of the registry. The principle behind the registry is to keep the integrity of the system in place by making sure that everyone is transparent and accountable.
I note a lack of concordance between Part 1 and Part 4 of the bill. When we look at the new power devolved to CSIS and even to the RCMP in a certain perspective, they do not seem to work and to maintain an effort possibly to deploy by the Commissioner Office, the new Commissioner Office. 2, the new position of Commissioner must be independent by reporting to the House of Commons, not to the Minister. As the Auditor General is currently doing, it should report directly to the House of Commons. Reporting to the Minister will only replicate or perpetuate the existing problem. Independence of the office of the Commissioner must be also financial. The protection of our democracy must be protected from...
I'm sorry, sir, I'm going to have to ask you to wrap it up.
Wrap it up?
Yeah.
Yeah, yes, sir, I will.
Take 30 seconds to wrap up, if you could.
Sounds good. Donc,
So, it's also important that the Office of the Commissioner have the possibility of investigating. Right now, that person can make reports to the Minister, and that's not enough. I welcome the inclusion of organizations from the education system. For example, even today, organizations such as the Alpha Group, which preaches a revised and biased interpretation of Chinese history, have succeeded in obtaining changes in school curricula. This organization was created and continues to be under the control of the United Front Work Department, the same as the Confucius Institutes. I'll end for the moment, and I'll be very happy to take your questions as soon as possible.
Thank you very much. We go now to Mr. Schul for an opening statement of up to 5 minutes, please.
Thank you very much, Mr. Chair, and to the distinguished committee members. Thank you for the opportunity to speak on this important bill. It's a pleasure to be here, and maybe I'll start by saying something that you probably don't all hear very often. Thank you very much. It was a real pleasure to see this bill proceed with the pace and with all the work that you're doing. And we're independent and nonpartisan. So when I say this, I really genuinely mean it. I know how hard you're working. We're sitting here, in the evening, and everyone's working away to get this done. So thank you very much. It's in that spirit I plan to make 3 arguments. The first is that activities covered by the Foreign Influence Transparency and Accountability Act should extend to municipalities, and we need definitional clarity around who is a public office holder. Number 2, the registry and the commissioner should be in place before the next federal election. And number 3, the act should nest within a broader national security strategy. Now, let me tell you what I mean by those things. First, we need to extend this to municipalities, and we need definitional clarity. Now, in Canada, the preamble of a bill is an important tool for looking at its statutory interpretation. And I don't want to put everyone to sleep by talking about the tools of statutory interpretation, but let me just say, it provides an introductory statement that sets out the guiding principles, the values, the objectives of the legislation. So the preamble here for the Foreign Influence Transparency Accountability Act says, whereas efforts by foreign states or powers and their proxies to influence in a non-transparent manner political and governmental processes at all levels of government in Canada have systematic effects throughout the country that endanger democracy, sovereignty, and core Canadian values. I pause there to dwell on all levels of government and just the impact of that. And now we have to look at how it applies. The application of the Act applies to federal political and governmental processes, provincial territory governmental processes, and essentially the governmental processes of Indigenous groups and governments. Now you have to look at the definitions. You go through the definitions, and there's a definition of public office holder, but it's different in the Security of Information Act. And so we're not covering municipalities here, and we've got 2 definitions in the same bill about what is a public office holder that are different. So we're probably going to want to take a hard look at that. So if you contrast that with the Security of Information Act, what it says is every person commits an indictable offense who, at the direction of or in association with a foreign entity, engages in surreptitious and deceptive conduct with the intent to influence a political or government process, educational, governance, et cetera, with a democratic right in Canada. It goes on to define public office holder differently. And so now you've got two pieces of legislation wrapped up in the same bill, effectively trying to do the same thing with different definitions of what a public office holder is. So, and I wonder why you wouldn't have concomitant obligations for registration. So it's kind of two sides of the same coin. In my view, the SOIA provides the legal teeth to prosecute and punish covert foreign operations, while the FITA, I don't know if that's what we're calling it, but I'll call it the FITA, complements this by creating a preventive transparency regime aimed at exposing and deterring such activities through mandatory disclosure and public oversight. It's a dual approach, deterrence and hopefully long-term preventative transparency. So, number two, before the next election, we must have the registry in place before the next federal election. You got to, again, go back to the purposes of the act, like we did at the beginning. Systematic effects throughout the country that endanger democracy, sovereignty, and core Canadian values. Not might have systemic effects. The bill says does have systemic effects. It is a statement of fact. So if you were to meet that purpose, how can you not have it in place before the next federal election? It'd be a little bit like bringing a birthday cake for a Saturday afternoon party on the following Tuesday. You will have missed it. And so if you're to proceed, and I watched the officials testifying, if it's too hard to do it all at once, just go with the federal government, the federal election, roll it to provinces and municipalities separately and after. But you got to get the birthday cake to the party. Number three, it should nest within a broader national security architecture. The Defense Policy Update said we're going to do a national security strategy every 4 years. The defense policy is going to be updated every 4 years. We've got C-26 that went through this committee that I was happy to testify about. We've got the CSE Act that's due for an update, or was due for a review in 2022. CSIS is an act now on a 5-year review cycle. Bill C-34 on the Investment Canada Act. Like, this is all kind of coming together. And I think the point here is look at all the pieces of legislation and all the various strategies, critical minerals, intellectual property, innovation, research, economic security. Look at them systematically, because adversarial states are looking at them systematically, believe me, and it requires a strategic approach. And as I said at the beginning of this, I've had the privilege of speaking with some of you before. I know how hard this committee works, and I know that you can do it, but I would just encourage you to think strategically and not just do the whack-a-mole thing on one piece of law. Thank you very much, Mr. Chair.
Thank you, sir. We go now to Mr. McSorley for 5 minutes.
Thank you very much, Mr. Chair. And thank you for the invitation to appear today to speak to Bill C-70. I'm with the International Civil Liberties Monitoring Group, a Canadian coalition of 46 civil society organizations that works to defend civil liberties and human rights in the context of national security and anti-terrorism activities. Bill C-70 has been presented as legislation to address the threat of foreign interference. We recognize the importance of addressing this issue, particularly as we've heard in instances where governments are threatening individuals or their close ones in order to repress their ability to exercise their fundamental rights or engage in democratic processes. However, the changes proposed by this legislation go much further. If adopted, this bill will have wide-ranging impacts on Canada's national security, intelligence, and criminal justice systems. As such, it will also have significant impacts on the lives and fundamental rights of people in Canada. For example, providing CSIS with new forms of warrants, granting it extraterritorial reach for foreign intelligence activities, and allowing the service to disclose information to any person or entity in order to build resiliency could lead to increased surveillance, diminished privacy, and racial, religious, and political profiling. Powerful new offenses for actions taken secretly at the behest of foreign entities, while necessary, and including foreign governments and terrorist organizations, are punishable up to life in prison. Those could infringe on freedom of expression and association and raise questions of proportionality in sentencing. The bill would also transform how federal courts handle sensitive information that can be withheld from applicants or those seeking judicial review, undermining due process in courts through the use of secret evidence. A bill of such breadth requires in-depth study. We're very grateful for the work that the committee members are doing and recognize the amount of time and efforts are being put into hearings, as was pointed out, that are extending long today and throughout the week. However, we're still deeply concerned with the hastiness with which this legislation is being considered. Introduced barely a month ago, with a foreign interference inquiry ongoing, it will have gone through committee study within a week. This is even faster than the rushed 2001 study of the first Anti-Terrorism Act, which was in committee for a month. We're grateful for today's invitation. However, we only found out about our appearance on Friday afternoon. Colleagues from other organizations who would have asked to appear or submitted written briefs have said they will be unable to do so on such short timelines, let alone develop specific amendments to suggest for Friday's deadline. Rushing the parliamentary process, supported by a state of suspicion and ardent calls to protect national security, can lead to serious, negative, and long-lasting consequences. An expedited study also risks missing ways the bill could be improved to better address issues of foreign interference. We're therefore urging the committee to work with your colleagues in the House of Commons to extend your study of this very consequential bill. Apart from the process of the study, we have some specific areas of concern. First, modifications to CSIS's dataset regime are only tangentially related to foreign interference. Many of these changes relate to significant problems the National Security and Intelligence Review Agency identified in a scathing report on the regime. The necessity and potential consequences of these changes remain unclear and should have been addressed during a statutory review of 2019's National Security Act. We'd recommend removing these changes until such a review happens. I'd be happy to speak more to this further during the discussion. We're also concerned around the powers of disclosure in Section 19 of the CSIS Act. While we understand the goal of ensuring appropriate information can be shared, journalists and NCIRA have raised serious questions about how CSIS has handled the disclosure of sensitive information in the past. Bill C-70 also grants CSIS significant new production order and warrant powers. The changes come after years of the courts admonishing CSIS for misleading them in their warrant applications. Warrant requirements exist to protect our rights. They shouldn't be lessened, and especially not while CSIS's problems of breaches of duty of candor to the courts have not been resolved. Bill C-70 also changes the Security of Information Act, including new indictable offenses for the carrying out of any indictable offense, including relatively minor transgressions, if done for the benefit of a foreign entity. This, along with other new or modified offenses, would be punishable by either life in prison or consecutive sentences that could amount to life in prison, provisions that are normally reserved for the worst forms of crimes and raise concerns of proportionality in sentencing. Finally, we also have concerns about new sabotage offenses and proposed foreign influence registry, but I'll finish by commenting on changes to the Canada Evidence Act. Our coalition is fundamentally opposed to expanding the use of secret evidence in Canada's courts under the guise of protecting national security, national defense, and international affairs. Introducing a standardized system for withholding information from those challenging government decisions that have significant impacts on their lives will normalize this process and is likely to facilitate the spread of the use of secret information further into our justice system. Thank you, and I'm looking forward to the discussion and questions.
Good timing. So as you can see, the bells are ringing. You can see them, you can't hear them. That means that there is going to be a vote in probably about 25 minutes. We have unanimous consent to carry on, and I'm proposing that we carry on with 4 question slots of 4 minutes each. Are we agreed to that? Okay, so we start with Mr. Shipley, 4 minutes, please.
Thank you, Chair.
Monsieur le Président.
Désolé.
Sorry, Chair. 4 minutes? No, not 4 minutes.
We don't agree to this one. Ben, plus parce qu'on n'a pas beaucoup dans le total.
Okay, 6 pour chaque parti. 4 times 6 is 24.
Yeah, I know, but we...
And I was proposing that each party had 4 minutes, and then we would adjourn and go vote.
I understand, but overall, we don't, as a second tier party, we don't get much time. So we actually lose 2 minutes. Because since we go to the other round at 2.5.
We wouldn't have a second round unless we wait and come back after the vote and do a second round. Did you want to come back after the vote and do a second round?
I don't have a problem with that.
Yeah. I guess I'm asking the committee what to do here. Let's start with...
Chair, I think we'd have time for 6 minutes per party. That cuts us close, but we're in the same building. And
Are we agreed all to 6 minutes? Okay, we'll do that then. Mr. Shipley, then, please go ahead, 6 minutes.
Thank you.
Is that le règlement?
Point of order. would it be possible to re-invite the witnesses a second time, because we don't have a lot of time here?
Would it be possible to invite again the witnesses, because we don't have much time with them now?
Well,
I don't believe we can do actual work.
We're kind of running out of time here. Let's take it up offline and see what we can do. At this point, we would certainly ask the witnesses if they feel they can contribute more to submit additional briefs. We'd be happy to do that. But right now, we're running up against the clock here. So.
No. Okay.
Mr. Shipley, please.
I know we're incredibly short now. We can't each have 6 minutes. There's 24 minutes left, so it's actually 23 minutes. So what are we doing now?
So we have no unanimous consent to proceed. We either adjourn the meeting or we suspend and come back after the vote. What is the will of the committee? I'm sorry?
Can we go back to the original 4 minutes, 5 minutes?
Well, we need unanimous consent.
Well, I know I'm asking that. Maybe you could ask.
Do we have unanimous consent to go to 4 minutes?
Which is what we originally had.
No. So, that being the case, I'll suggest we suspend and come back after the vote. Point of order, Mr. Bittlett.
If we're going to suspend and come after the vote, can't we just go for the first few rounds and then just continue on and adjourn after that, rather than coming back for half an hour after? Do 15 now and 15
that works for me.
After.
So we'll carry on with 6 minutes until we start to sweat, and then we'll suspend and come back after the vote. Okay, Mr. Shipley, 6 minutes.
Thank you, Chair. So sorry, we got a little off topic there. Thank you to the witnesses for being here. My first question is for Mr. Juno Katsuya. Sorry if I butchered that a little bit. I do apologize. You were very adamant, sir, in your opening remarks that the commissioner must be independent and should report to the House of Commons. Could you expand a little bit more on that, or your thoughts on that, and why you're so firm on that, and how that would work?
Well, evidence were presented during the inquiry that even as we speak today, the director of CSIS had to return twice to his office to change report that was submitted by CSIS to the Prime Minister. The capability right from the get-go, from the outset of the creation of CSIS, to be capable to manipulate, control, and limit the information, the dissemination of sensitive information within the appropriate concerned parties, have been there from the beginning. We even have evidence there was obstruction from CSIS within the RCMP investigation, and I named 4 of them, where CSIS has voluntarily prevented the RCMP to receive some information to help in the prosecution of certain individuals. So in that perspective, it is obvious that, unfortunately, the system was geared to manipulate, to control. And it's only when or many whistleblowers had the courage to show the evidence publicly in the media that we finally are addressing a crucial question for and a crucial threat against our Constitution. So in our perspective, to my point of view, it's evident that CSIS is too influenced by or subject to influence from the Prime Minister's office or his staff. It's difficult for the RCMP also to be neutral and to investigate adequately. So to my point of view, in all fairness to all the parties, the commissioner should be reporting directly to the House of Commons, just like the Auditor General is doing, and therefore being capable to release the information adequately to protect our system.
Thank you for that. And my follow-up and second question is to you, sir, and also Mr. Scholl, because in your opening remarks, you mentioned that provinces definitely need to be involved in this, which I found interesting. Then Mr. Scholl mentioned specifically municipalities need to be involved. So I found it a little interesting that you both pick different levels of government. Maybe you could each take your time and expand on how they should be involved and why you're seeing more of a provincial issue and yourself, sir, more of a municipal issue.
I share the perspective for the municipal as well. We have seen foreign interference at all levels. Politicians, as soon as they have power at all levels, have been approached by foreign states to manipulate them and to control them. My last comment is that provincial governments are investing collectively billions of dollars every year in research and development in universities and everything. And we have been having many foreign agents stealing property, intellectual property, and no protection at all is started or initiated from the province because there's no advisors, no national security advisors with the premier of every province. And when the offer was given to them to receive a special briefing from CSIS last June, only one premier in BC accepted the invitation. All the other refused. There's a certain naivety that is close to stupidity here when we start dealing with this.
Thank you. Mr. Shaw, would you
Yeah,
add
and
to
on
that?
the municipal point, I mean, this is a national sport, not just a federal sport. But my comment was more related to the actual application of the law itself. And municipalities are excised from the act, and I couldn't provide a good reason why. I think it's where democracy touches people the most. Like if your kid's school gets hacked, your hospital goes down, your water turns off, your electricity turns off, people will know. So municipalities are where democracy touches people the most and the closest, and they're not in this bill.
Thank you for that. And perhaps, and not to put Mr. McSorley on the hot seat between you two, but definitely Mr. McSorley felt like we need to take our time, and I agree we need to do the right thing. But time is of the essence with this legislation. Perhaps you two gentlemen could speak to the urgency of getting this legislation passed, and what is the risk if we do not have these mechanisms in place by the next election? Both of you, if you'd like. Sorry, Mr. McSorley.
Definitely, it's long time overdue. As I reported, I was chief of Asia Pacific. I served for over 21 years for CSIS. I've been in the game for over 40 years, and I've witnessed from Mr. Mulroney to Mr. Trudeau, everybody being corrupted, everybody being sort of influenced by agent of influence within their inner circle. So it's more than late. And unfortunately, we're paying a dear price as well because now our foreign allies are looking at us as a bunch of Mickey Mouse leaders because we're not taking the right steps. So this is very urgent that we have a law that defines or a legislation that defines what foreign interference is about and what the punishment can be so the investigators, the RCMP or other police departments can do their job.
And I would just say, when I read words in a bill that like systemic effects, endanger democracy, sovereignty, and Canadian values, I start to pay attention. And the point is this, right? Yeah, the bill's not perfect. Yeah, we're doing it fast, but it's better than nothing. And the point, and I would just say, if you've got a review mechanism on the bill, get out the door with it, put some miles on it, and then make changes after.
Thank you, Mr. Shipley. We go now to Mr. Biddle. We have 17 minutes before the vote. Did you want to have your 6 minutes now or wait?
6 minutes now, if
absolutely, go for it.
Agreed to. Let's get going and not waste more time for the witnesses. I appreciate everyone being here. Mr. Schewel, I was wondering if you can comment. Heard from officials that they believe municipalities to be covered by the legislation because they are not independent entities. They are creatures of the province. Do you accept that explanation, or still have concerns?
It's one, but I wouldn't like and I totally get what they're saying. And as a matter of law, municipalities are creatures of the province. The absolute worst possible outcome, though, is that you catch someone in this and then you get turned around at court. What's the reason? Just add some words, make sure that they're explicitly covered.
No, that's fair. I appreciate that. Monsieur Juno Katsuya, with respect to advisors to the premiers, is that something that can be covered through legislation or something that we Because if you give the
covered by
example, sorry, go ahead.
the leadership of the federal government. The federal government is responsible for national security, rightly so. It should encourage the premier to be capable to appoint national security advisors that will be kept informed. One of the big problems that we had in our system is that CSIS was prevented to share information for too long with too many people. We need to be capable to share information and to be capable to, because the only real defense we have against foreign interference is awareness, awareness, awareness. If we do not warn people, if we do not develop certain reflex to do better business, we are going to be taking over.
Do our allies provide this type of advice to other tiers of government?
The MI6 and the MI5 each year host a national conference inviting, for example, business leaders to receive the latest threat assessment that they are perceive during their work, and share also defense mechanism. They even have a special in England, a special departments where companies can call and receive some training and assistance in order to protect themselves better. So the government needs to understand that 86% of our national infrastructures are either owned or operated by the private sectors. So we need to be in cooperation with them. For the provinces, it goes in the same perspective as well. As I try to point it out, billions of dollars are invested every year in national research, and we're losing that because we don't have the consciousness of what's going on.
So is that something, back to my original question though, is that something that we can legislate, or is that just a cultural difference and a direction that the British government has taken, or is it something that we can address in this particular legislation?
If we legislate, I suspect, tip of my head, I suspect there will be a pushback from the province because they will claim that there is a certain territorial issue. But definitely stewardship should be sort of, and leadership should be promoted within the national security culture that needs to be developed, which is another element as well. We do not have a national security culture. And when I'm talking about that, I'm not talking about a state police. I'm talking about developing reflexes collectively as a society in order to understand that we need to do business differently and to understand. And when we talk also about the various levels, municipal, provincial, and federals, we've seen, and there are currently people in charge of some of the largest largest cities in Canada that had been agent of influence from the Chinese government and had been positioned before at other levels. So it's the domain of politics is crossing over political levels as well.
Thank you so much. Back to Mr. Schewel. How do the provisions in C-70 compare to legislative schemes enacted in other Five Eyes countries to counter foreign interference and influence?
You know what I'll do? I'll submit a written brief on that. My colleague Wesley Wark is the guru, and he wrote a CG paper on this. So rather than me coming off the top of my head, I'll submit it in writing. But he did a full assessment of the U.S., the UK, and Australia, and also a review of Canada's law too. So I'll submit it.
Thank you so much. Can you speak to the newly proposed information sharing provisions found in the bill?
I'm all for them. So yeah, I mean, realistically, like my colleagues around the table had said, you know, a big threat vector is the private sector, and we were unable to share information with them, provinces, municipalities, and so if hostile state actors are doing what hostile state actors are going to do, you're going to want to be able to share that information, and this goes a long way to remedying that deficiency.
I believe I only have about 30 seconds left, so I'll cede the rest of my time. Thank you so much.
Thank you, Mr. Biddle.
Chair, on a point of order.
Mr. Shipton, on a point of order.
There's been some discussions. I think you might find UC to have us all vote remote and just work through it now. If you wanted to.
Okay. So I understand there has been discussions among all members that we will carry on through the vote, and we will vote through the magic of our telephones, and pause only very briefly. And for those uninitiated, we have to do this funny thing. So it's not magic. It's technology. So we will carry on with Mr. Villemure, if you wish, 6 minutes, s'il vous plaît.
Merci beaucoup, Monsieur le Président. Monsieur Junot,
Thank you very much, Mr. Juno Katsuya. What do you think of the idea that the registry rather could require a double registration? So the foreign agent and the person who is the object of influence. Absolutely necessary. Yeah, that's absolutely necessary, that idea of double registration. The existence of a registry, the idea, it's already in place with the lobbyist registry, and we see all kinds of manipulations and schemes, things that go on behind closed doors already. If we want to have the certainty that there is transparency and accountability, not only must the foreign agent report the meeting within 14 days and the subject of the conversation, but the person who received the visit must also. So that way, everybody stays honest, if you like. If there's a difference which is seen between the report of each individual, then we'd be able to investigate that and have a much better investigation. Thank you. Mr. Schuhl, the same question for you in terms of double inscription in the registry.
Thank you very much through you, Mr. Chair, for the question. I mean, I think the registry, the way that it's structured is pretty good. I mean, it fixes a gap. It's not the end state though. It's one tool in a broader toolkit. So the way that it's written currently, I think is okay. I think you're raising some good questions around this table about independence and where the commissioner should sit and all of that. But as it's currently structured, I think the registry does a pretty good job of remedying the evil that it's designed to catch.
Merci beaucoup. Monsieur Junot Katsuya, selon vous, la situation qui a eu lieu au rapport...
Thank you. The situation at the lab in Winnipeg, if a registry had been in place, as has been proposed in C70, would that have had an impact on that situation? Well, that's a very good question. I'm not sure. I can't say at this moment if having a registry could have prevented this situation. Certainly, we need to have a much stronger verification of certain things. There were policies and mechanisms that were in place and which were not respected, and that's the major problem here, the fact that the procedures weren't followed. So these aren't so much foreign agents as people who became Canadian citizens over a certain period, so in theory, but as of the moment when they received contributions and collaboration from a foreign agency, as we saw, an agency which is directly linked to the People's Liberation Army of China, well, certainly at that time, they certainly should have reported that and reported their contact. But so what do we do if we had scientists who were stealing IP, for example? We can't imagine that they would sign up as IP stealers, so that we'd need to have certain controls in place. Yeah, absolutely, and that's why we need to develop a new culture of national security, as I was saying a few moments ago. And I think that Bill C-70 is a step in the right direction, which will allow us to start to define an operating framework for investigators who will be able to determine if there are dangers or problems. And so the fact that school institutions are included, that's great. That's really good, because that's where we see the greatest theft of IP right now, and that's been the case for decades. So if you understand, it's good to have the structure, but there also has to be a culture of national security. Yes, absolutely. And that culture, if you want to put that in place, it takes leadership. That leadership has to come from the federal government, which will authorize and promote awareness campaigns, partnerships with the private sector and with the provinces to increase and raise general awareness across Canada. Thank you. Mr. Schuhl, I'll come back to you. You mentioned earlier municipalities, but should we also include universities and public companies as well, or rather crown corporations? So in Part 4 of the registry, we talk about universities. What do you think of that?
Yeah, I mean, I think that there's an important thing to be said for universities. And let me give you, for instance, when the debate was going on about Huawei and 5G, I brought in ATIP and I pulled the access for a record called Compute Canada. And there's no reason that you should know what that is, but Compute Canada was set up as a intensive computing processor for many of our most in research-intensive universities. Guess who built the back end? It was all Huawei. And so that goes to what I was saying about my broader approach to national security as a strategic framework. It's not just investments over here. It's not just minerals over there. It's not just foreign registry over here. It's all of it. And so I think we just need, it behooves us, because hostile state actors are behaving in a strategic way, we need a strategic response.
Merci beaucoup. Comme M. Biddle,
As Mr. Biddle did, I will now cede my time to my colleague.
Merci. So we have 5 minutes and 27 seconds. Did you wish to, for us to pause for the moment, or do you want to start your questions?
I'll just go right to the voting time.
Okay.
Thanks, Chair.
So, committee,
No, he's saying he'll ask.
Oh, go. Okay. Sorry. I misunderstood.
Thank you, Mr. Chair. Mr. Shull, I'd like to start with you quickly. I'm glad you brought up the consistency between SOIA and the new Foreign Interference Transparency Accountability Act, because I did note that with the Department of Justice officials when I questioned them last week, and they just to paraphrase, they just said that the definitions used in SOIA are within the context of SOIA, and there's a reason for this difference. It can be confusing because in the definition of public office holder, specifically in Part 4, it does reference other acts which are more comprehensive. But I guess you're arguing to this committee that just for harmony's sake, let's just have SOIA and this act have the exact same list.
They're going after the same evil. And if I know exactly what you're saying. It references the Lobbying Act, but if you go to that provision of the Lobbying Act, it's actually enumerating things to which the Lobbying Act does not apply. And so it's like a double negative and a circuitous definition. Just call it. Just say what you mean.
Thank you for clarifying that. Mr. McSorley, I'd like to continue with you. You've outlined the multiple concerns that you have with some of the provisions in this act. I just wanted to center in on the disclosure rules as written in this for CSIS. I think I understand the rationale behind it. We do want to make it easier for the service to notify people who may be in positions of concern. But I think, other than a few exceptions that sort of govern how CSIS can release this information, it's really just up to the service, and it's not clear to me what the recipient of the intelligence would then do with it. Do you have some suggestions for what this committee should do with that particular section? Are there additional safeguards you would like to see in this to govern how CSIS releases that?
Certainly. Thank you through the chair for that question. Well, there's two key areas there. One is about personal information that could be shared with ministerial authorization, and there's information that doesn't contain personal information, but that can be shared more broadly for building resiliency. And so in terms of what the minister can share, including personal information, we're concerned that's being opened up to any person or entity, and we have grave concerns about international information sharing and how that can have effects on the rights of Canadians who are traveling or people abroad. And so we think that there should be greater safeguards around how the minister, even ministerial authorizations, can be shared. And it's important to note that under that, there's a safeguard that requires that those kinds of disclosures be reported to the National Security Intelligence Review Agency. And that's a very important safeguard. And unfortunately, under the new provisions for sharing information for resiliency, no such safeguard exists. So we think that maybe one of the things that could be considered is that there be reporting and transparency when CSIS is sharing that information for resiliency. And the reason for that is that, as I mentioned, there's been reports, both through NCIRA and others, around how the information is used as a follow-through. So, for example, even when CSIS shares information through its threat reduction measures, NCIRA found that they don't take responsibility for charter breaches that could arise from how that information is being shared. And so we think that by having more accountability and transparency, even if it's just within NCIRA, could help to ensure that there's follow-up and some kind of ways to ensure that it's not being used to violate the Charter, and also to ensure that the veracity and accuracy of that information is being shared, because as we've heard today, sometimes that's at issue too in terms of what CSIS is sharing. And if it's shared with a university, how would they know whether or not that's accurate or right, unless there's some kind of follow-up by another body?
Yeah, thank you, because I did read in Sarah's report on the CSIS's data set regime, and it was pretty scathing. And so, I'm concerned that if they blew past the legislative safeguards that exist today, I'm just a bit cautious as a legislator for giving them even more. I understand the rationale, but I don't want to be here in another 5 years reading another scathing NSERA report because they blew past our legislative safeguards again. So I take your point on that. Very quickly, in Part 4 of this Act, I've had multiple witnesses talk about the problem with the definition of arrangement and being in an association with a foreign principal. Do you have any concerns about that? Do you think we need to tighten up the language there?
I think there needs to be some clarity around that, and I think that would help improve the effectiveness of such a regime, so it's not overly broad and capturing all kinds of things that maybe isn't being envisioned. So, for example, one of the concerns we have is around the definition of foreign economic entity or foreign entity, and whether or not that could capture, for example, public broadcasters from other countries that are essentially under the control and ownership of a foreign government, and whether or not that could mean that journalists who work in conjunction with them, or Canadians who appear as pundits and speak about important policy issues, could then be forced to register. And we're worried that that would have a chilling effect on journalism. And there's other questions around academic freedom and other areas as well.
Oh, yeah. Okay, so let us pause, suspend for like a minute, and we'll do the vote. And
Yeah, can we not just keep going? There's 10 minutes of each of us to vote. Or if you need to.
I'm
we can
happy to
pause at
keep
that
going,
point.
and we can vote in the process. This is so unusual. We have such agreement all the time. Okay. Yeah. So let's start our second round. We will start our second round with Mr. Caputo. You have 5 minutes.
Thank you, Chair. I want to focus on one aspect, and this was actually raised by another witness. It's something I asked about previously, and that is the independence of the registry, the commissioner for the registry. Sorry, I don't have the formal name, but you know what I'm talking about. That'll be established here. Now, at this point, there has to be, as I understand it, consultations with a Parliament, with the House of Commons and the Senate on the naming of that person. But the commissioner would be appointed by an order in council. Is there any way to strengthen the independence of that person? Does the commissioner appear sufficiently independent based on that sort of appointment process to the witnesses?
Well, there's a number of commissioners that report directly to Parliament. The Privacy Commissioner of Canada being one. You look at the lobbying commissioner. I think that when I watched the previous witnesses as well too, and if I could understand the reason behind it, and again, I'm just some guy, so take this for what it's worth. It's that they nest within the department, so they have access to the material. Because ultimately, once you start issuing compliance notices, where's that information going to come from? It's going to be coming from intelligence sources, and so I think the idea is to have them nest, and so that might gravitate toward bringing them closer into the department. But I definitely hear your point about the independence.
We focus very much on the positive element of people having to register, people having to excuse me, voluntarily report within 14 days, etc. But what happened in the execution when we have delinquent? When we have people who do not want to report or try to sort of hide the meetings that they had with people in office and everything, or elected officials. And that's where we need to have the investigative capabilities. Now, somebody would say, we'll give it to the RCMP. As I tried to demonstrate a little bit earlier, the RCMP and CSIS do not cooperate very well together currently, and have not been sort of capable to be resisting the influence coming from the Prime Minister's office in particular. So that kind of interference that comes from within our system is to the detriment of the quality of our democracy.
Can you elaborate on that? What interference from the Prime Minister's office are you referring to?
Well, when you have CSIS that goes and report that there is one of their candidate that has been greatly compromised and the buses of foreign students have been brought in, and they say, not really sure that the intelligence is really good. I think we'll disregard that and we'll continue. Somewhere, somehow, there is a sort of a lack of responsibility here and respect for the professionalism of that institution that we have created that is there to protect our country. Same thing when certain investigations are not initiated when they should be initiated because it might embarrass the Prime Minister's office or something like that. That separation that has been thought at the beginning between the judicial and the legal and the executive is missing now and has been missing for a long period of time. And we need at this moment, at this crucial moment, to try to recreate that separation by having an element of independence as much as possible, both financially and in terms of authority.
Now, could there? So you've struck me with this idea of independence, and you've had a very good example of it. I think that one of the arguments against somebody who's truly independent, like say, I'm just trying to think, conflict of interest, right? They're not part of the government. Would a contrary argument be, well, the commissioner is going to have access to departmental information at the ready? Is that an argument to perhaps not have the same requisite level of independence, the same degree of independence? Does that make sense?
We can legislate to make sure that he or she has access to all the information that is needed for the investigation. That is a sine qua non in the success of their investigation and the deterrence that we want to apply to foreign agents. Because rest assured, foreign interference will not finish with the passing of C-7E. It will continue. It has been in place for a long period of time. We dragged our feet so long now that they have been capable to embed themselves within all levels of government, so it will continue. But my problem is with the execution. Are we giving the tools for the law enforcement to be capable to work adequately, especially when we have evidence now in testimonies that tells us that influence from the higher office has been exercised many, many, many times.
Thank you, Mr. Caputo. Go now to Ms. O'Connell, please. 5 minutes.
Thank you, Chair. Thank you to all the witnesses for being here. Actually, Mr. Katsuya, if I'm saying that right, I'm sorry if I'm not. I want to follow. Okay, thank you. I wanted to follow up kind of in that line of questioning, because given your experience, certainly the issues around independence, I think it might be unfair to suggest that because in dealing in some of these areas that all of a sudden independence is gone, because the challenges around turning information into evidence is challenging in itself. At what point do you stop and say, well, here's information that is relevant, and let's make an assessment there, but then more information comes in and the assessment has to change? Doesn't that then also compromise Canada's ability to make good policy or CSIS to provide advice if there is a cutoff point for information, instead of actually being able to review puzzle pieces of information to form that greater picture?
I do not want to lack disrespect, but we do not act on information. We act on intelligence. And we produce intelligence. We do not collect intelligence. Intelligence comes from information plus an analytical process that puts together the intelligence. And from the intelligence, we take a course of action. We turn that into actionable intelligence. The independence that we've been talking about currently is necessary because, unfortunately, and I stress, not only in the current years, but for the last 30 years, we've seen agent of influence being capable to literally hijack the process and deter from taking the right actions from the government or other departments. And it doesn't need necessarily an army. it needs just the right person at the right place. It's called a minister, it's called a director general, it's called a deputy ministers who will say, no, that's not really good. I reported back in 1998 foreign interference. We had evidence at that period of time. I was ordered to destroy my document and my information because it would embarrass the government at that point. I was doing my job, so they rather killed the messenger rather than to go after what was a threat to our national security. And that's the problem here, and that's why we need to be able to have, just like the Auditor General, that's the example that I prefer to use. The Auditor General sometimes talks about issues that are difficult, that are sensitive, that are embarrassing. But it needs to be said, this is the only way we'll have a healthy and solid democracy, by having this transparency and this element of accountability that I was mentioning earlier.
Perfect. Thank you so much. Mr. Schull, I want to move to you. Actually, both of you mentioned the issues around including other orders of government. And certainly, I appreciate you reading out kind of the intro of the bill, because I think the intention is quite clear to make sure that the CSIS Act, which right now doesn't allow for information sharing at all and is quite restrictive, opens it up. So I'm curious about your specific advice around the definition of public office holders to bring that in line, because it's not just municipal, provincial, could be Indigenous leadership that hold critical infrastructure as an example. Is there a definition in another act or in other countries that you think would be more in line with kind of keeping it more broad?
Yes, through you, Mr. Chair. It's a great question. It's in this bill. It's actually in the SOIA. So all I would do is take the SOIA definition and move it over, and then you're home free. And then you've got congruity between your pieces of legislation. So that's all I would do. And then and I would also just add municipalities in explicitly. The honourable member's point is a good one. You could probably make an argument that municipalities are creatures of the province, but I if I was defending somebody on this, that's the first place I would go. And I just why just forestall it at this stage.
Thank you. And just following up on that, I mean, I certainly was in municipal government, so I understand, and thinking about my time then, knowing kind of what I know now. But the challenge is, and I want to hear your thoughts on this, is the assumption that then all information will then just be shared, because part of the challenge is making sure the information is shared and different orders of government are given that, but in a way that then doesn't compromise the information. So how do we find that balance to make sure, whether it's universities, whether it's private businesses that are targeted, how to ensure that we can create legislation that's broad, but doesn't create this expectation that everyone's going to receive a national security briefing and then therefore that information no longer is protected?
Through you, Mr. Chair, another good question. I mean, we were talking about two things. One is, the requirement to register. And so at the municipal level, if you're trying to influence a municipal official on behalf of a foreign principal, you should have to register. Period. And the reason is so that we can have some transparency. And then if you don't, it's a little bit like Al Capone. They didn't get Al Capone on murder; they got him on tax evasion, right? And so this just provides another tool in the toolkit. So I think that's point number one. Point number two, with respect to the sharing of classified or secret information, I'm going to leave it to the experts on that. Like, they don't teach you anything about how to share top secret information in law school, so I don't even want to bother to hazard a guess.
Thank you.
Thank you, Mr. Collin. Well,
challenge, and it's an excellent challenge that you're talking about. It's about the culture. Canada has been really prude about sort of hiding and sharing information for decades and decades and decades. We need to be capable to be a little bit more mature, a little bit more grown up about sharing information, and what is shared is not always going to be the detriment. On the contrary, it is to reinforce our national security. Thank you, Mr. Chair.
On y va maintenant, Monsieur Villemur. 2 minutes.
Now over to Mr. Villemur, 2.5 minutes. Thank you, Chair. And in 2.5 minutes, I have the same question for Mr. Junot Katsuya and Mr. Schull. So there are ministers, elected officials who worked in collaboration with China, for example, when they left their mandate afterward. Should we have a moratorium of 3 years or 5 years where former ministers or public officials couldn't do business, for example, with China, given that it could be a problem? Yes, absolutely, absolutely. If we were to take inspiration from what's taking place in the private sector, when people work for certain companies, they then have a requirement to respect some restrictions or stay silent, or even aren't allowed to go work in certain fields for a certain period of time, so as not to share sensitive information or to help a competitor. Here we're talking about national security. In previous governments, we saw that there were 5 members of cabinet who went directly into working for Chinese companies as soon as they left, and that's an aberration. It's completely unacceptable that cabinet ministers who had access to privileged information, the most secret information in the country, be able to go and work for and profit from companies by sharing that information. Mr. Schull, on the same subject.
I have to guess that cabinet ministers take their oath seriously. So I've trust and respect for people that aspire to this office and for members around this table. If you swear an oath, I think people are going to uphold it. But I do think a cooling off period is not a bad idea. I don't understand why we wouldn't want one. And so I haven't given it much thought, so I'll leave it there. But I think just instinctively, it seems like a good idea to me.
Ça semble pas inusité à tout hasard.
Well, it certainly seems like it exists elsewhere, so it could be a good idea. If there was something that we learned from the Australian registry, Mr. Schull, because it's referred to often, but we often forget to mention that there are some who were critical of it. So what should we avoid based on the Australian experience?
I would say you want 2 or 3 things. Number one is clarity, absolute crystal clarity. People need to know what's expected. They need to know what's required of them. And then there needs to be sharp and swift intervention if they don't. And right away, the absolute worst possible outcome is we work sitting around this table, set this thing up, and it does not do what it's meant to do. That is the biggest thing to avoid. And so that's why I'm glad we're having this conversation. But I would say get it right, but get it out before the next election, whatever we do.
Même question, s'il vous plaît.
Same question for Mr. Junot Katsuya. Yes, it's very, very important. Since 2017, when Australia passed its act, there have been no charges since then. And as Mr. Schull mentioned, and I agree with him, there's a lack of clarity, there's a lack of clear and specific definitions, which would allow the forces of law and order to properly investigate and bring charges before judges. We also need people who have the backbone to stand up. Thank you.
Mr. McGregor for 2.5 minutes.
Thanks, Mr. Chair. Mr. McSorley, when I was reading through this act, of course, there's a lot of harmony in the various federal statutes that are being amended, for a purpose. However, the one section that does stand out a little bit are the amendments to the criminal code, specifically on page 35 and 36 of the bill. It's clause 60 and 61, really amending the criminal code's definition of sabotage. In a previous round during this meeting, we heard testimony from the World Sick Organization, who noted that there's a reference here to the safety or security of the naval, army, or air forces of any state other than Canada that are lawfully present in Canada. This could mean military attaches at an embassy. They said that in previous examples, the Indian government has tossed around spurious accusations about protests around their diplomatic missions, etc., and they're worried that this could be used to unfairly target certain groups. I did ask them if they were okay, because there is a for greater certainty clause here, that this would not apply for anyone who's participating in advocacy, protest, or dissent and do not intend to cause any harms. Do you have any thoughts you want to share with the committee on that, these specific amendments to the criminal code, and anything that we might need to look at?
Through the chair, thank you very much for the question. We do have concerns about the amendments to the Sabotage Act. It is good to see that there is an exception considered. We're concerned that it may not go far enough. We know that when individuals engage in dissent, that there are often accusations that they are going too far. And we're worried that the way that is currently framed, especially questions around what is meant by the intent to cause harm, could be cause a chilling effect. So, for example, a protest that is crossing a railway or that is going on a road that is used by emergency services, the intent is to protest. It may lead to the disruption of those services. The individuals may not intend for that harm, but they know that that could happen. They know that an ambulance, and everyone would know, is that an ambulance may want to pass, that a train could be passing. And so we're concerned about where the line will be drawn in terms of what is considered intent. And obviously that's well defined by jurisprudence, but we're still concerned that it could lead to a chilling effect and result in individuals not participating in their and exercising their democratic right to protest and express freedom of expression and association.
Thank you, Mr. McGregor. So that wraps up our second round, and Mr. Kirk is concerned. No?
I have another committee that's starting momentarily.
Okay, so I believe we're done. So thank you all for your testimony. Oh, and Mr. Caputo wants us to talk about the schedule. So the witnesses may feel free to leave if they wish. So.
Can you adjourn the meeting if this is off? Is this just casual? Because if you have to leave.
Okay, meeting adjourned.
Thank you.